Good morning, ladies and gentlemen. This is Judge Jesse Lal, and we're going to begin with our Fulton County State All-Purpose Calendar. This is a calendar for misdemeanor criminal cases which are still active and pending. Individuals have already been accused, formally accused by the prosecutor, which is the Solicitor General's Office of Fulton County, with one or more misdemeanor offenses. Today is what we call our plea and arraignment calendar. For certain cases, the defendants may have conferred through counsel with the prosecutor to reach an agreement with regards to entering a plea. Other cases are present here today because they are going to be arraigned, in other words, formally charged, upon which they will enter a plea of not guilty, and the case will be then scheduled for trial in the future with the division judge. I would just like to remind anyone who's been charged with a misdemeanor offense or offenses today, you do have the right to remain silent about the facts of your case. Anything you say about the facts of your case during the course of this virtual, recorded, and live streamed proceeding, your statements can and will be used against you. So please keep in mind, this entire proceeding is not only live streamed, it is recorded. So please be mindful of what you say and let your attorney speak on your behalf. You have a right to an attorney. If you cannot afford one, a member from the Public Defender's Office will represent you, or an appointed conflict counsel will be appointed to represent you. Okay, if we have private attorneys on the Zoom conference, I can only advise you that we will have to wait until the jail staff brings your client forward. I have no control over the rotation of the inmates. So please, if we don't reach your client immediately, please be patient and we'll try to reach you as soon as possible. Mr. McLean, are you planning to join us in the office, or you're okay where you're at?
Right where I'm at, Your Honor. I'm about three blocks away.
All right, as long as you are parked and safe, that's good. Thank you. All right. Where are we beginning? Fulton County Jail at courtroom 2 or 6L? 6L?
Yes, we got number 9, Mr. Chong.
Thank you, sir. Position number 9, we have an announcement pending. Okay, we have Austin Chong, accused in case 22 CR 0000149Y of misdemeanor possession of marijuana from 2019. Okay, Mr. Chong, you have been advised of your right to remain silent. Your appointed counsel is going to be Mr.
Your Honor, I can speak to that case, Your Honor.
All right, and let me see, Mr. McLean, what's the announcement for Mr. Chong's case?
Your Honor, not guilty. Bond is moot. It would be best if we were to put that to a different SAP in the future. I spoke on the phone with Calpin Shaw, who is his attorney on his felony case. That's why bond is moot, is he has a felony case with no bond. And that attorney has not yet received his discovery in that case. And while it may be a stretch, it might be speculative on whether this case would affect that. That attorney would prefer, and I think that makes sense, that attorney would prefer that nothing be done today until he gets his discovery, looks into it, and makes sure there's nothing whatsoever related to free him to go forward on this.
This case was on January 11th, 2022, according to the booking sheet. And Mr. McLean, why should I not arraign the case today? It's
You
still
could
going to
arraign the case today. That would not prejudice rights. That would be fine.
right. Is your client aware that he's entering a not guilty plea today?
I could ask him in a breakout real quickly if he understands what Mr. Shaw's instructions are. That would be important.
Mr. Chong, are you planning to enter a not guilty plea today?
Yes, I'm not sure.
Speak up, please.
Yes.
All right, Mr. McLean, may I proceed with the arraignment?
Yes, we can, I can show him, Your Honor, the accusation and give him a copy. You could formal arraignment or, what the read either way.
I will read the accusation to him. All right. Just give me a
All right.
moment to get to his case. Mr. Chong, I understand that you presently are represented by Mr. Mike McLean in this misdemeanor case for possession of marijuana from 2019. As your attorney has also indicated to us, you do have other pending matters in Superior Court of Fulton County, through which you are represented by another attorney, Calvin Shaw. Are you aware of that?
Yes.
All right. In this misdemeanor state court case, as we've already indicated, you plan to enter a plea of not guilty, whereby your case will then be scheduled for trial in the future. The time of the date of the trial is not certain at the present time. So all I'm going to let you know is what is the accusation. In other words, what's the charge brought against you? And then once I've advised you of what's going to happen, I understand you're going to enter a plea of not guilty. Do you understand, sir?
Yes, ma'am.
All right. Mr. Chong, in case 22 CR 0000149Y, you've been accused of possession of marijuana less than 1 ounce, allegedly occurring on August 25th, 2019 in Fulton County, Georgia, in which the Solicitor General for the County of Fulton has stated that on that particular day and that particular county, the accused willfully obstructed and hindered Jay Reese, a law enforcement officer, in the lawful discharge. Hang on, is this? All right, Ms. Duncan, what are we doing? Did we add more charges to this case?
Your Honor, I just received the calendar. However, I did see the information about the possession, and it was linked to the state court case. Let me go to it 1 second, Your Honor.
All right, right now he's only accused of possession of marijuana. So he has been accused in which allegedly on August 25th, 2019 in Fulton County, with that said accused did unlawfully have under his possession or control less than 1 ounce of marijuana in violation of Georgia law 16-13-2, contrary to the laws of the state, good order, peace, and dignity thereof. Okay, that is the accusation that's been filed by the Solicitor General on January 11th, 2022.
That's correct, Your Honor. The obstruction is NOD.
All right. So that's the only charge that is pending against Mr. Chong. Mr. Chong, this is the misdemeanor offense that's been brought against you. Number one, you're presumed innocent of this charge until the case goes to trial. Upon your entry of a not guilty plea, the case will be scheduled for trial. During the course of that trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. That is the current law in the state of Georgia. And given this information, how do you plead?
Not guilty.
All right, your case has been arraigned, is going to be scheduled for trial. Your attorney, Mr. McLean, and your other attorney, Mr. Shah, are going to confer and discuss what are the next steps to take in your case. Mr. McLean, if your client and the prosecutors all decide to move forward with a plea, you would have to make sure it's scheduled before Judge Edie, unless you want to schedule it on any of our SAP calendars.
Very good, Your Honor.
All right, thank you. That concludes this case.
Good morning, Judge Law.
Good morning.
This is, whenever you're ready, this is going to be 12, Mr. Hodges.
We have position 12, State versus Time Hodges, case number 22 CR 000073H. And Mr. Hodges' case, Mr. Hodges, you've been advised of your right to remain silent, and your attorney is going to be Mr. Mike McLean. Is that correct, Mr. McLean?
Yes, Your Honor.
All right. And let me just confirm one thing on this case. All right, Mr. Hodges, are you aware of the charges been brought against you? Mr. McLean, have you spoken to your client?
Yes, Your Honor.
Okay, good.
I'm not, because
So-
I
Just a
haven't,
second, just a second. Mr. Hodges' case has not been arraigned yet, Mr. McLean. So I understand that you want to have a bond modification hearing. Is that correct?
That's correct.
All right. Before I proceed with a bond modification hearing, the case will be arraigned. Has your client been advised of such a proceeding?
I have shown him the accusation and he understands the charges. So I didn't tell him specifically he would be arraigned.
All right. And has he been advised to, have you spoken to him about entering a not guilty plea?
Yes, he is not guilty and is pleading not guilty today.
All right. All right. And do you waive a reading of the accusation, Mr. McLean?
We do.
Okay. Mr. Time Hodges, in this particular case, I understand that you are aware of the misdemeanor offense brought against you. Is that correct?
that's what I was gonna say. I was gonna say that, when I was at Cobb County,
Your Honor, this is going to be a challenge. He likes to not follow advice to remain silent on other matters.
I understand.
Mr.
Thank you,
Time-
Mr. McLean.
that was-
Mr. Hodges, you and I have spoken before, so let's make one thing clear. First of all, you get to answer my question. And then if you have anything else to add, you will do so after I've finished arraigning the case, and I'll ask you, Mr. Hodges, do you have anything to say? Do you understand?
yeah,
Okay, so right now, all you're going to do is answer my question. And if you fail to do so, if you fail to follow my instruction, I will then reset your case for another week, and then we'll see you next week. Do you understand?
yeah,
All right. Be very careful how you conduct yourself. First of all, Mr. Hodges, you have been accused of a particular misdemeanor offense. Are you aware of what the charge is brought against you?
I was gonna just say that I did not get to see them, hear them. Yes, I'm not.
So
totally-
are you aware of what the charge is against you, or are you not aware?
Well, I'm just gonna say they said that I touched her breast. That's all I was told.
Okay. Given the context of the nature of the charge, I will deem it that you are aware of the misdemeanor offense that's been brought against you. It is a battery of a certain nature. The alleged offense date is December 1st, 2021, allegedly in Fulton County, Georgia. And you are formally accused of this particular offense, to which if you enter a plea of not guilty, the case will be scheduled for trial. At the time of the trial, you will have the assistance of counsel to challenge the state's case, as well as to present any defenses you may have. And you will do so through the assistance of counsel if you qualify for representation of the public defender's office. Now, during the course of the trial, please remember that the prosecution, the state, has the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state does not meet its burden of proof, you will be acquitted and discharged of this offense. However, if the state does carry its burden of proof and the trier of fact does convict you of this offense, then you could face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead in this case? Guilty or not guilty?
Not guilty.
All right, thank you. Your case has been formally arraigned. Your attorney is Mr. Mike McLean. Now, Mr. Hodges, if you make any comment about other open cases, the facts of this case, or anything related to a defense in this particular case, without going through your attorney, you risk the possibility of making statements that will not only incriminate you, but it will also jeopardize your defenses that your attorney is going to work so hard to present. So if you decide to say something now and waive your right to remain silent, you're going to do so against your attorney's advice and also jeopardize your particular case. Now, I'm going to ask you a very simple question. Do you have anything else to add?
Yes, I do.
All right, Mr. McLean, your client plans to say something. Shall I let him proceed?
I would prefer not, Your Honor. What I would like to do is launch right into my bond request.
Mr. Hodges, your attorney has advised you against saying anything and he would like to argue for your bond. Will you allow him to do so?
I want to speak, but you know, he can ask for the bond, but I do want to talk though.
Might be better, Mr. Hodges, for you to listen before you speak.
Do you understand, Mr. Hodges?
I said, I want to talk. I just wanted to say that this, like you guys going over it. I'm trying to say that this never happened. I don't even know the person. This never happened. That's okay. So now that we got that out the way, and I did 16.
Okay, Mr. Hodges, let me interrupt you for a second. I'd like to argue your bond. You told me what factors you'd like for me to argue your bond, and I agree that the factor you mentioned to me, I will talk to the court about, and that will be your bond argument.
All right,
Thank you.
Mr. McLean, you have the floor. He's got a $5,000 cash bond at the present time. What would you like me to address?
He's asking for a signature bond, Your Honor, and he's pointed out to me that he has had 2 tours of duty in the military, that his first discharge was honorable, and that his second discharge was honorable. He went into the Marines, served, got an honorable discharge, came out of the Marines, had a gap in there, thought about it, and decided to re-enlist in the military. This time he went into the Army, and he received a discharge, which is an honorable discharge. I will follow up on his statements to me, and I will check with his family and check on the accuracy of that. But as best I know at this point, that is correct. And those are the main points. Service in the military, being a veteran is one of the main arguments, or the main argument he'd like to make on why he would like to have a signature bond, that he is trustworthy and honest, and he will show up. He will show up for court.
All right, thank you, Mr. McLean. Ms. Duncan,
Yes,
there is a $5,000 cash bond. Any argument to maintaining it?
yes, Your Honor. The state believes that the bond should be maintained. The circumstances surrounding this bond being issued have not materially changed. And I'm sure Your Honor is aware of the facts of the case, and the fact particularly that after this incident, about 2 days later, the same defendant was arrested for or cited for the same offense at a different college or university against a different victim. So given the facts of this case and the nature of the case, the state will request that the bond remain the same.
All right. Do you have any verifiable information that Mr. Hodges is a former military, former veteran of the military?
Not to my knowledge, Your Honor.
All right. Mr. McLean, from the time this bond was instituted, I have not seen any discernible change in circumstances. The bond will remain the same with no further contact with the alleged victim.
Hold up. How when I was at Cobb County, I had 3 misdemeanors. I got a $3,000. Hold on. Let me say something. I got a $3,000 bond at Cobb County for 3 misdemeanors. Can I talk? How did I get a $3,000 bond for 3 misdemeanors? I got a $5,000 full cash bond here. That makes no sense. A misdemeanor is $1,000. That's why it's called a misdemeanor. I didn't do like. And then here's another thing. As far as the military part is going, I was in the Marines for 4 years. Honorable discharge. I went to the Army. Went to Iraq for people being killed.
Deputy Francois, we are concluded with this
Honorable
case.
discharge.
Thank you. Deputy Francois, I will allow you to control the courtroom and then
Wait, hold up.
move
No,
on to our next case. 5 North, who do we have, please?
This is number 10, Mr. Coleman.
This is Mr. Alante Nason Coleman, accused of simple battery domestic violence from December 3rd, 2021 in case number 22 CR 000075F. Mr. Coleman's case is represented by private counsel. Who do we have representing Mr. Coleman?
Yeah, Adam.
Jay Adams.
Edward Adams. Edward Adams.
Oh, Edward Adams, okay.
Right, is Mr. Adams on?
I don't, let's see, is Attorney Edward Adams on the Zoom conference of anyone who is from his office?
Your Honor, I have a phone number to which we can send Mr. Adams.
All right, if you'd like to put the phone number in the chat to Miss April Champion or to Mr. Michael Jordan, we will try to reach out to him. 5 South, we can only address Mr. Coleman's case when his attorney, Ed Adams, is on the Zoom. Ms. Coleman, have you spoken to your attorney recently?
Yes, I did talk to him yesterday.
Yesterday, was he aware of this hearing?
Yes, ma'am.
Okay, we will reach out to him. Maybe he's having problems with the Zoom link, and we'll see whether we can get him on as soon as possible, okay?
Yes, ma'am.
Thank you. 5 South, 5 North, do you have someone else to address?
Not up here, I don't.
All right, we'll have to get back to you as soon as we get Mr. Adams back on the Zoom. Thank you.
Okay.
Thank you. Courtroom 2, who do we have, please? Courtroom 2, who do we have, please?
This is position 13, Mr. Horton.
All right. Mr. Sylvanus Horton, case number 22 CR 000071D, is accused of criminal trespass and causing damage to property and one additional count of criminal trespass. This is from a January 5th, 2022 incident. Mr. Horton, you've been advised of your right to remain silent, and your attorney is Mr. Mike McLean. Mr. McLean, we are addressing a plea today.
Your Honor, let me turn to the correct page. What number is Mr. Horton?
Position 13. I've got a note that it's the announcement is for a plea.
That is correct. I've been authorized by Mr. Horton to sign for him, and we'll turn those papers in later. He is asking the court to allow him to have a negotiated plea, but I will point out, even though it is a negotiated plea, that he is agreeing to do his darndest to afford and take and complete the theft class. He is without funds. He is homeless, and that will be difficult. And I said I'd point that out to the court, but I asked him, did he want me to make that turn it into a non-negotiated plea? And he has a very clear idea of the difference, at least he did yesterday, and said, no, I'm going to do my best on the theft class, but just have the court aware of it.
Understood. Thank you. At the present time, Ms. Duncan, you may move forward as a negotiated plea, and we will take it from there. What is the state's offer?
The state is recommending 12 months to serve, 30 days, credit for time served, 15 days, stay away from 463 Peachtree Street, no further contact with Ronnie Dennis, balance probated in the theft class.
All right. And Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do, Your Honor.
All right. And in consideration of his current situation, do you have a good mailing address for Mr. Horton?
On mailing address, he'll probably use one of the churches or one of the charities that has a good mail drop for people who are homeless.
All right. Has he identified any yet?
Not to me, Your Honor. Is St. Luke's a good one, Mr. Horton?
Let's unmute courtroom 2. Mr. Horton, we need a good mailing address where you can be reached and where your probation officer can reach you through the mail. Do you have an address identified?
Yes.
And what would that be?
I'm gonna say it now.
What would that address be?
5603.
You need to speak up, sir. Sit up straight and speak up.
Don't pull your head down, though.
5503 Riverdale Road.
Was that 5503?
Yes,
And which city is that in?
Hodge Park.
And what is this location?
Riverdale Road,
Yes, what is that location?
an apartment complex.
It's an apartment complex?
Yes, apartment. Ready for the number?
Yes?
Apartment 2B.
2B as in boy?
Yes.
And who lives there?
Someone I used to know. They would just allow me to use their address.
And what's their name?
You want me to say their name?
Yes, please, unless you want to tell it to the deputy and the deputy can put in the chat to Miss April Champion.
Can I do that?
You sure?
Your Honor, if I can intervene, we could just make a time serve offer in consideration of the defendant's current situation. I don't believe our office had that information previously, but considering what has been presented to the court, we could just do time serve and no further contact with the victim.
All right, Miss Duncan, are you prepared to modify the sentence accordingly?
Yes.
Okay. So, Mr. McLean, the prosecutor has now made a different offer. It will be 12 months to serve 30 days, credit for time served 15 days, to stay away from 463 Peachtree Street, no further contact with Ronnie Dennis, balance suspended.
Much appreciated, Your Honor.
All right, well, thank Mr. Walker and Ms. Duncan, more so. All right, Mr. Horton, apparently the new offer now is that if you decide to plead guilty to these charges, we will consider your time at the Fulton County Jail as sufficient penalty. And you're not required to do any classes, but you have to stay away from 463 Peachtree Street, and you cannot have any contact with Ronnie Dennis. Is this something you'd like to consider?
Yes.
All right, you do understand that you have to stay away from the location.
Yes.
And you cannot have any contact with Mr. Ronnie Dennis.
Yes.
Okay, so please raise your right hand. Do you solemnly swear and affirm that the information you provide is the truth, is the truth to the best of your knowledge?
Yes.
Are you under the influence of any kind of medication, drugs, or alcoholic beverages?
No.
Are you under the, I'm sorry, what was that?
No.
Okay. I do know it's difficult with the mask, but if you can speak up, it would really help. I'm trying to hear your responses, okay?
No.
And you've been represented by Mr. Mike McLean. Are you satisfied with this representation?
Yes.
Mr. Horton, if you decide to plead guilty to one count of criminal trespass and damage to property and second count of criminal trespass, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to have the assistance of counsel, to confront your accuser, challenge the state's case, present evidence of any defenses you may have, argue your case to the judge or jury, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
No. You told me to stay away from Peachtree, right?
No, sir, I haven't reached that point yet. I'm just saying that if you decide, listen very carefully, if you decide to plead guilty to the charges brought against you, you will not be able to go back to court. You will not have a trial before a judge or a jury. You will not be able to confront your accuser, examine witnesses, have the assistance of attorney to challenge the state's case, to present evidence of any defenses. And also you would have to give up your right to have the prosecutor prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to the charge of criminal trespass causing damage to property and criminal trespass?
Yes.
Accept your guilty plea. Your sentence is 12 months to serve 30 days, credit for time served 15 days. Given the 2-for-1, you would have served your time at the jail. Once you are released, you are to stay away from 463 Peachtree Street. If you return to that parking lot, you will be arrested and brought back to jail with a new case. You're also to have no further contact with Ronnie Dennis. You have any questions?
No.
All right, balance suspended. That concludes this case. Thank you.
Thank you, Your Honor.
Courtroom 2, do we have another case?
Next, we have position 19, Mr. Lovett.
Okay, thank you.
Good morning, Your Honor.
All right, good morning, Mr. Long. All right, sir, we are addressing Derek Lovett in courtroom 2, case number 22 CR 000089J, in which he's been accused of criminal trespass and willful obstruction of an officer, allegedly on January 6, 2022. This is position number 19. And Mr. Lovett, you've been advised of your right to remain silent, and your attorney is going to be Mr. Mike McLean. Mr. McLean, I understand this is going to be a non-negotiated plea. Is that correct?
Yes, Your Honor. He and I had a good, lively discussion of the legal factors, and he definitely wants to plead. He's just simply going to ask the court to consider not having the extra jail days.
Okay. Mr. Lovett, in a non-negotiated plea, I'm first going to hear from the prosecutor as to what the recommended sentence is, and then I will hear from your attorney, after which I will let you know which alternative I'm accepting, and then you can make the decision as to whether you want to move forward and enter a plea of guilty or no contest. Do you understand, sir?
Yes, ma'am.
All right. Mr. Long, what's the recommendation?
Thank you, Your Honor. The recommendation is 12 months to serve, confinement 90 days, credit for time served 15 days, balance suspended, stay away from 530 East Paces Ferry Road, which is the Ashley Gables Buckhead Apartments, and it would be concurrent on each charge. The basis for the recommendation is that we believe he's a risk for reoffending since he did return to the same location after being previously told not to return, not even 2 months prior. We also believe he's a risk of not returning or reoffending in other capacities as well, based on history. He does have history, 10 total cycles going back to 2008, starting with an obstruction 2008, simple assault carrying a concealed weapon 2011. That was a conviction. 2011 false imprisonment from Cobb County, conviction. 2013 robbery by intimidation, guilty, convicted. That was first offender, 2 years incarceration followed by 9 years probation. And then 2014 theft by receiving, an obstruction conviction, 2015 probation violation with 4 years confinement. So based on the history, based on the facts of this case, we're recommending the 90 days.
Our pretrial officer is Ms. Harvey. Ms. Harvey? Does Mr. Lovett have any open cases or any prior convictions for trespass in other jurisdictions?
The last arrest was, let's see, it's out of DeKalb County for criminal trespass and theft by receiving stolen property. That was August 6, 2021. Let me see what the disposition was for that case. 1 moment. That was a misdemeanor conviction, Your Honor.
Do you have a disposition date?
He was sentenced August 26, 2021, credited with time served 45 days.
And was he convicted of the criminal trespass in that charge?
Yes, criminal trespass and theft by receiving stolen property misdemeanor.
That was August 26, 2021, and this incident is on January 6, 2022. All right, thank you. Mr. McLean?
Yes, Your Honor. Figuratively speaking, the light bulb has gone off in Mr. Lovett. He says that he now understands. We discussed the law. And while a tenant of the apartment complex had invited him, he says, I told him that the tenant's invitation cannot cannot trump the stay away. And he was mistaken as to law. And I explained to them a mistake of law, as opposed to a mistake of fact, is not going to be a defense. So he understood and said, gee, I just didn't get that then. Just there waiting on that tenant. I went into the hallway on the 6th floor. They confronted me, and I really didn't mean to do anything wrong. So he asked the court to have mercy on him for that. The state was correct that he did have a previous first offender. And of course, that would not constitute a conviction per se. It was 8 years probation following the 2 years instead of 9.
All right, anything else to add, Mr. Long?
Nothing further, Your Honor.
All right. Mr. Lovett, I am going to accept the state's recommendation, given the nature of your recent conviction in DeKalb County and the fact that the documents do not make any reference to an invite from an unidentified resident of the property. I find that this second offense within less than 6 months was particularly egregious, and I'm going to accept the state's recommendation of serving additional time at the jail. Mr. Long, how many more days would he have to serve at the jail? He's been in custody now for 15 days.
Based on the 2-for-1, I believe 30 more days.
We concur.
Mr. McLean?
We do concur. 30 was our calculation.
All right. Mr. Lovett, you would have to serve 30 more additional days at the Fulton County Jail. And once you've completed that time, the remainder time on your sentence will be suspended. In other words, you will not be on probation, but you would need to stay away from 530 East Paces Ferry Road, the entire Ashley Gables apartment complex. And if you return there, you will be arrested for criminal trespass again. Would you like to move forward with the plea, or would you like to enter a not guilty plea and have your case scheduled for trial?
Can me and my lawyer break out?
Certainly. Mr. Francois, we're going to address Mr. Lovett's case towards the end of the calendar because I have other cases to address with Mr. McLean.
Okay, that's fine. Or if he wants, he can call in a courtroom, Judge, and have a talk with him.
All right, Mr. McLean, when you don't have a case, if I'm addressing another case, you can call 404-612-2392.
That's correct.
2392, got it.
All right, have a seat over there.
Next case, please. I'm going to address 4 South. Who do we have at 4 South?
31, Mr. Sharkey.
Repeat again.
31, Mr. Sharkey.
Okay, and who represents position 31? Jerry Sharkey?
That'll be me. It's my case, Judge.
Mr. Howard? All right. Mr. McLean, please use this time to contact your client in courtroom 2. Okay, we are addressing position 31, and this is Mr. Jerry Singleton Sharkey, accused of simple battery and simple assault in case number 21 CR 006-359C. Mr. Howard, Mr. Sharkey, you've been first of all, you have a right to remain silent. Anything you say about the facts of your case during the course of this proceeding, your statements can and will be used against you. You have a right to an attorney, and representing you at the present time is Mr. Derek Howard. Mr. Howard, has your client been arraigned yet?
Judge, he may need to be arraigned, Judge. Yes.
All right. Okay, so Mr. Howard, you're recommending to your client to enter a plea of not guilty to these charges. Is that correct?
That's correct, Judge.
And do you waive a reading of the accusations?
Yes, Judge. We talked
All right.
about it
Thank
last
you.
night.
Oh,
Is it Mr. Sharkey?
looks like he was arraigned on November 30th, 2021. So then I think and then there was a bond order reduction. His bond was reduced to a $5,000 surety bond on November 30th, 2021 by Judge Morrow. So this case should have been further noticed for trial. But I understand you are seeking a reconsideration of a further reduction. Is that correct?
That's correct, Judge, but I do have the person sitting in front of the camera.
Let's see. The individual in 4 South, is your
Okay.
name Jerry Singleton Sharkey?
Okay, I think I'm looking at the wrong courtroom. Okay, there we go. I was looking at courtroom 2, so I see Mr. Sharkey now.
Yeah.
Yes, Judge. And Judge, our request, Mr. Sharkey has been living here in Georgia for more than 20 years. He is currently disabled. He receives or was receiving a monthly amount for a disability that he has. He also shared with me that, and he was okay with me sharing this with the court, that he has a cancerous tumor on his left kidney that he's had for the past 2 years. And he says that he's not receiving adequate medical treatment related to that here at the jail. He's certainly concerned about being able to be released so that he can follow up with the specialist to make sure that his health stays on track. Obviously, the court is aware of the COVID outbreak at the jails. This makes him particularly vulnerable given his pre-existing condition. And Judge, I showed that his bond is currently set at, let's see, $2,500 on the simple battery charge.
I think he's got a split bond.
Split bond, okay. All right, he has a split bond. Judge.
No, it's a $5,000 surety bond,
And-
according to the last order entered on November 10th, 2020.
Okay. And essentially, Judge, he obviously has not been able to make that. He's been in custody for a total of 87 days. We would ask the court to take that into account, given that bond is not meant to be a pretrial sentence, but also, to ensure that someone returns to court and to be able to answer these charges, which he intends to do. So we would ask the court to convert his bond to a signature bond so that he can receive the proper treatment and answer these charges outside the Fulton County Jail.
All right. Mr. Long, anything else to add?
Did you want to get a history from pretrial, Your Honor?
Sure. Ms. Harvey, can you tell me if Mr. Sharkey has any convictions for any kind of assault, battery, or trespass issues in the last 2 or 3 years?
He's on probation for simple battery in a public transit vehicle or station. He was sentenced August 1st, 2021 to 12 months probation. Let's see, this 2017 disorderly conduct. I did not see any other battery, but he is a multi-state offender. So let me check other states. One moment, Your Honor.
Mm-hmm.
Let's just theft out of Texas. Do not see any battery. Looks like everything seems to be theft, Your Honor. It's like 4 other states that he has charges out of, so.
Thank you. Mr. Long?
Thank you, Your Honor. We're asking that the bond remain. I do show him in on a $2,500 surety. There was a theft by receiving that he was booked in as well for, but that case is showing as dismissed. So maybe that's where the other $2,500 went.
looks like he's got 2 counts, simple assault and simple battery. And it looks like he was booked in on the simple battery, but the state added an additional count of simple assault.
Yes,
Yes,
that is correct, Your Honor. That is correct.
okay.
We're asking that the bond remain. We do believe that he's at a high risk of flight. Pretrial mentioned that he has history out of 4 other states. I find it interesting that he told his attorney that he's lived in Georgia for 20 years because he has history from New York in 2013 and 2014. He has history in Virginia for a failure to appear in 2015, history in Texas for convictions, multiple convictions in 2016, an FTA out of Philadelphia, Pennsylvania in 2018, back in New York in 2018, conviction for theft charges. Given his 2 FTAs, we believe that he's at a very high risk of reoffending. 16 cycles back to 2004. Also, we haven't received any paperwork corroborating his medical condition, and there's been no material change in circumstances since his previous bond was addressed. So for those reasons, we're asking for the bond to remain.
All right, thank you. Anything else to add, Mr. Howard?
It's just that I think the biggest change is he's been in jail almost 3 months, which there comes a point where bond is irrelevant. The person is sentenced by bond. And so I would just ask the court to take that into account, the amount of time he's been in.
On the simple battery, we're going to keep it at the 2,500 surety bond. On the simple assault, it's going to be modified to a 2,500 signature bond through jail. This was a charge that was added after, and there was no warrant to support that particular charge. So it's a $5,000 split bond. No further contact with the same victim, and to stay away from the store at Piedmont Road. I believe that was a Marshall's.
Yes, Marshall's at 2625 Piedmont Road Northeast.
Yeah. Thank you. Mr. Coleman's case has been arraigned. This case is going to be further noticed for trial. Courtroom 2, can I address position 10, Mr. Coleman, very briefly, please? Thank you. It's going to be very brief. If he wants to just come in.
Mr. Coleman's on 5 North, Your Honor. He's not in the courtroom.
Oh, I'm so sorry. I'm so sorry. Okay.
Yeah.
If 5 North wants to bring Mr. Coleman forward.
He has to wait. 4 South has to go to 5 North.
Okay, no problem. I just want to let them know that the case is going to be reset to February 3rd. His attorney has requested that the case be reset.
Okay,
So,
yeah, I read that in the chat also.
All right, thank you.
We have position 32, Mr. Smith, Deronta Smith in front of you now.
Thank you. All right, Deronta Smith is 22 CR 000090E, accused of 2 counts of driving under the influence. One is less safe, the other one's a per se count, hit and run, and 2 counts of following too closely. Mr. Smith, you've been advised of your right to remain silent, and your attorney is Mr. Derek Howard. This is position 32. And Mr. Howard, I understand this is going to be a non-negotiated plea. Is that correct?
I'm just on, right, the only issue is the jail time, Judge, that we're
All
contesting.
right, understood. Mr. Smith, this is going to be what we call a non-negotiated plea hearing. So I am first going to hear from the prosecutor, and then I will hear from your attorney. I will let you know which option I'm going to select, and then you make the decision as to whether you want to proceed. Understood?
Yes, ma'am.
Mr. Long?
Thank you, Your Honor. The state's recommendation was to enter a plea of guilty to count 1, 12 months to serve. Count 1 would be DUI less safe. Count 12 months to serve, 180 days. Credit for time served, 15 days. Balance probated, $1,000 fine, 40 hours of community service, risk reduction program, alcohol drug evaluation treatment, MAD impact panel, no drugs, alcohol, and random testing. Count 2, which is the DUI per se, would be null prost. Count 3, hit and run would be 12 months probation consecutive to count 1, $500 fine, no drugs or alcohol, and random testing. Count 4, driving too close, would be 12 months probation consecutive to count 3, no drugs or alcohol, and random testing. And then count 5 would be merged with count 4. So there'd be a total of 36 months of probation, with the jail being on count 1. The basis for the state's recommendation is that we do believe he's at a risk for reoffending. He appears to be on probation for some serious felonies dating all the way back to 2006, armed robbery, aggravated assault, hijacking motor vehicle, possession of firearm during commission, ×2, where he did a prison sentence and then was put on probation. Then after getting released, he had our case in August the 3rd, 2021. And then there appears to be a warrant out of Fayetteville from municipal court from October 13th of 2021. And then there was an arrest from January 3rd of 2022 for simple battery, family violence in Union City. And then based on the facts of the case, we believe that his conduct was egregious. He was a driver in 2 separate vehicle collisions. The first occurred Metropolitan Parkway and Casplin Street Southwest, where he struck the vehicle belonging to Kevin McKeithen. He did not stop during that collision and fled the scene. The driver, Mr. McKeithen, had noticed the defendant's vehicle approaching at a high speed in his rearview mirror, and the driver attempted to get out of the way, but was struck on the right rear bumper. And the first driver followed the defendant's vehicle to get the plate, and he saw a second collision. The second collision occurred at Metropolitan Parkway and St. John's Avenue, where the defendant struck the rear of Lester Graham's Cadillac, and Mr. Graham at the time was stopped at a red light. The defendant's vehicle then rolled backwards from that collision down the hill and struck a light pole at 1959 Metropolitan Parkway, where he was found unresponsive and taken to the hospital. The police found an open cup in the vehicle containing alcohol. The driver appeared to them to be under the influence, and a search warrant was obtained for the toxicology from Grady, showing a 0.20 blood alcohol level. So for those reasons, we feel that the jail and the probation length is justified. Thank you.
All right, thank you. Mr. Howard?
Yes, Judge. Mr. Smith is 32 years old. He's a lifelong Georgia resident, still has family that lives here in the metro Atlanta area as well. Judge, he freely acknowledges that he was 17 years old when he was convicted of the felony charges. He served significant time for that. He's paid his debt to society for those felony charges. He has grown since then. While he was incarcerated, he was able to complete his GED as well as get a certified paralegal assistant certification from Ohio University, which is a program offered through the prison system. He was actually working for DHL as a forklift operator at the time of his arrest. He had been on that job for 2 years. So he's obviously concerned about being able to maintain stable employment to help support his 1-year-old daughter that he adores and that he wants to continue to support financially and to be present with her. Judge, this is his very first DUI offense. As the state mentioned, he did suffer a severe medical event as a result of this accident. He tells me that he was told that on 2 different occasions that he coded, as the term is used when someone is deemed to have passed away, and he indicates he was revived, or they told him he was revived twice, once at the scene and once at the hospital. And he was not obviously arrested. He wasn't even aware of the charges because they didn't give him a citation or anything at the time because of his medical condition. Judge, we believe the 6 months in jail is excessive. We would like the court, given that he has no prior history related to any type of alcohol consumption, we'd ask the court to consider time served so that he can get back to work. He obviously needs to maintain his employment, to maintain his obligations with probation, as well as to maintain his financial obligations in his home. So we would ask the court to consider a reduction to time served on that with all the requirements and conditions. I think the state mentioned that there was 36 months that they were requesting, but I thought it was only 24. On number 4, Mr. Long, I think it says 12 months probation concurrent to count 3, which means there will be 2 years of probation as opposed to 3, according to the offer that's on the calendar. So we discussed that it will be potentially 2 years of probation. So we would ask the court to follow that recommendation and just reduce the jail time.
All right.
You are correct, Mr. Howard. I do see that count 4 was to be concurrent with count 3 for 2 years probation total.
All right, thank you.
All right. I'm going to accept the defense's recommendation, and the sentence will be 30 days, being given credit for 15 days, after which he will be placed on probation. While he's on probation, he will be on 24 months probation. Count 1 would be for 12 months time served, a balance probated, and then count 3 is 12 months consecutive to count 1, and count 4 is going to be concurrent to count 3. So he will be on 24 months of probation, during which time he will report to probation every month, be subject to random testing for alcohol and drugs. Of course, if he fails any of the screen tests, probation has the discretion to revoke his probation and have him serve out the rest of the 24 months in prison. He will have to complete the risk reduction program, an alcohol and drug evaluation program, a MAD impact panel, not consume any illegal drugs and no alcoholic beverages for the remainder of the 24 months. And I'm also going to impose an interlock device onto his vehicle in the first 12 months of his probation, so that device, he would have to use that device to start his vehicle. So we would need to know which vehicle is registered as his name so that he can have the device installed for the first 12 months. So, Mr. Howard and Mr. Smith.
Judge, I guess I have a question about the interlock requirement, given the significant cost associated with having that placed on a vehicle. And if he otherwise, does not have any restrictions to his driving based on it being a first, would the court consider some other alternative as it relates to the interlock? Typically that's reserved for a person with multiple DUIs. And in this instance, he doesn't have a history, Judge. And it is thousands of dollars, I believe it can be to put that interlock device on a vehicle.
I will increase his community service to 80 hours.
All right. Thank you, Judge.
This is a particularly egregious situation, first time DUI or the 10th time DUI, given the allegations to which if the client is stipulating to the factual basis.
Yes, Judge.
I think this is more than generous on the part of the state.
Yes, we agree, Judge. Thank you for your consideration. He's certainly mindful of that.
All right.
And
Mr.
Your Honor,
Smith, yes, Mr. Long?
Oh, I apologize. We were just going to say that we'll send the license suspension notification form to Mr. Howard.
All right. Is he given a first offender affidavit?
Yes, Judge. He should be eligible for that. So if we could complete that as well.
So, Mr. Smith, you will be on probation for up to 24 months. You cannot consume any illegal drugs and no alcoholic beverages. You'll report to probation every month. You need to pay off your $1,000 fine within the first 12 months of being released. And you need to complete your 80 hours of community service, risk reduction program, alcohol and drug evaluation, the MAD impact panel, all within the first 12 months of your release. After which you will then serve another 12 months for count 3 and count 4. You'll be on probation for 24 months. Is this something that you want to accept, or would you like to go to trial?
I accept.
All right. And Mr. Howard, do you stipulate to the factual basis, venue, and ID?
We do, Judge.
All right. Mr. Smith, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Mr. Smith, we are going to consider the plea for 22 CR 000090E in which you were originally accused of 2 counts of DUI, 2 counts of following too closely, and hit and run, failure of the driver to stop or return to the scene of the accident. Based on the recommendation today, you would be pleading guilty to 1 count of DUI, driving under the influence of alcohol, less safe. You'll be pleading guilty to hit and run, as well as 1 count of following too closely. Is that your understanding?
Yes, ma'am.
All right. First of all, are you under the influence of any kind of medication, drugs, or alcoholic beverages?
No, Your Honor.
And are you satisfied with the representation of your attorney, Mr. Howard?
Yes, Your Honor.
Is anyone forcing you or inducing you to take a plea today in exchange for the recommended sentence?
No, Your Honor.
And if you decide to plead guilty to these charges, you do understand that you would have to waive your constitutional rights to go back to court, to have a trial before a judge or a jury, have the assistance of an attorney to present your defenses, challenge the state's case, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, Your Honor.
If you also decide to take this plea, you will also have to waive your right to appeal my sentence or modify the sentence in the future. Are you prepared to do that?
Yes, Your Honor.
How do you plead to 1 count of DUI, driving under the influence of alcohol, less safe?
Guilty.
How do you plead to 1 count of hit and run, failure of the driver to stop or return to the scene of the accident?
Guilty.
And 1 count of following too closely?
Guilty.
Accept your guilty plea for the DUI charge. Your sentence is 12 months to serve 30 days, credit for time served 15 days. The balance will be probated. Within the first 12 months of your probation, you must pay off your $1,000 fine, complete 80 hours of voluntary community service, complete a risk reduction program, and complete an alcohol and drug evaluation, and submit yourself to any treatment as required. Complete 1 MAD impact panel. And while you're on probation, you're not to consume any alcoholic beverages, no illegal drugs, and you will be subject to random testing by probation. Count 2, DUI per se is null-pros. Count 3, hit and run. The sentence will be served consecutive to count 1, and it is 12 months to pay a $500 fine, which may be done within the 24 months that you're on probation. Again, no illegal drugs, no alcoholic beverages. Report to probation every month and be subject to random testing. With regards to count 4, it will run concurrent to count 3. It's 12 months to be served on probation. No alcoholic drugs and no alcoholic beverages and no illegal drugs, and subject to random testing. Count 5 will merge into count 4. You will receive a first offender's affidavit, which means that you may drive a vehicle subject to limited privileges by the Department of Driver Services. Do you have any questions?
Yes, ma'am. Will I receive instructions on how to go about the stipulations that you set before me through
Yes.
mail?
When you report to probation, they will give you a list of qualified providers where you can complete the programs. You will need to report to probation every month, pay your probation fees, pay your fines in the schedule I just sentenced.
Thank you, Your Honor.
All right, good luck, sir. Be careful.
Your Honor, South Ennis, can we go next, please?
No, I'm sorry, South Annex. We still have a whole lot more to do. We're gonna go with position 30, Mr. Richardson.
Position 30, we have Mr. Richardson. Let me just see. Eric Emmanuel Richardson is case number 15 CR 005099. Mr. Richardson has been accused of driving under the influence of alcohol, less safe, and driving under the influence of alcohol per se. This is from a May 10th, 2013 incident. And with regards to this particular case, Mr. Richardson, you've been advised of your right to remain silent, and your attorney is Mr. Derek Howard. Mr. Howard, you're asking for a bond modification in this particular case. Let me just confirm a couple of things. He was arraigned on September 7th. No, hang on. He had a plea and arraignment calendar on September 7th, 2021 before Judge Porter, in which he failed to appear and his bond was forfeited. So I gather that he, and then PD in, all right, that's been a motion filed by the surety in this particular case. So Mr. Richardson is in jail because of a bench warrant issued by Judge Porter where he failed to appear on September 7th, 2021. Mr. Howard, shall we arraign the case and move forward to the bond if you still want to have that considered?
Yes, Judge, that'll be fine. We waive formal reading.
All right. You can unmute courtroom 2, please.
I changed that. I don't want to waive the arraignment, and I would like to speak to Mr. Howard.
All right. Ms. Francois, if we can place Mr. Richardson to the back, and Mr. Howard, if when you get a moment, you can call the jail. You have the number?
Sure. Yes, Judge. I have
All
it.
right. And Mr. Richardson and Mr. Howard will confer. Next case in courtroom 2.
Position 25, Mr. Marcel.
Mr. Isaac, is it Isaac McQuiller?
That's you. Okay.
I have a Marcel and I have
a
different name.
Lombardo Marcel.
Okay, just give me a second, please. Oh, it's position 21. Sorry, that was my bad. I thought it was 25. Mr. Lamberto Marcial is accused of criminal trespass in case 21 CR 0075888H. Mr. Marcial is needing a Spanish interpreter. Do we have our interpreter on Zoom? We do not have an interpreter on Zoom. So we cannot address Mr. Marcial until an interpreter is available.
Yes, Judge, we can move on to the next while we wait.
Okay.
Sit over there. Next, we can do position 4, Mr. Barry.
Thank you. All right, Mr. Barry is represented by Mr. McLean. This is Montres Arenda Barry. And with regards to Mr. Barry, his case is 21 CR 0056322H, in which he's accused of criminal trespass causing damage to property, 2 counts of simple battery, domestic violence, and 1 count of simple assault, domestic violence. Mr. Barry, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. Mr. McLean, I understand that you want to address bond in this case. Is that correct?
Yes, Your Honor.
All right, just give me a second. Looks like we had a couple of amended accusations filed.
Your Honor, if I may interrupt, I apologize. This case was actually before Judge Taylor.
Okay.
I'm handling this case for the state. Now, he was supposed to plea on January 14th, but unfortunately, there's something going on because of COVID. They couldn't transport him to plea before Judge Taylor, so they moved his case to this calendar. So
okay, thank you. I just wanted it on the record today that his case has already been arraigned on November 2nd, 2021. So if we are, Mr. McLean, were you aware of the reset to this calendar for a particular plea?
No, Your Honor. Thank you for the information. Does the Assistant Solicitor General believe that Judge Taylor would object to us addressing bond today?
I do not think so. Now, I believe the public defender, assistant public defender, Clarissa St. Flex was handling the case for him before Judge Taylor. So I already submitted all the plea paperwork. I'm not sure if Your Honor has it or if Your Honor needs me to send it over.
Oh, just a minute. April, do we have the plea paperwork for Mr. Barry?
No, ma'am.
All right, we don't have any of the documents. And the only announcement I got from from the public defense is that this is going to be a bond modification hearing. So do y'all want to proceed, or shall I don't want to send it back to Judge Taylor. I don't want to make a ping pong or pendulum effect in this case. So
I agree. Is it a time served plea?
He agreed to time served, balance suspended, and no, I believe it's no contact with the victims involved in the case. And I will no process remaining charges. I'm not imposing family violence intervention program because of the defendant's circumstances. He currently he was on probation for aggravated assault. Case number is 19 SC 164697. His probation was revoked and he's currently on a probation revocation calendar on for January 24th of this year. And he currently has an open pending criminal damage to property case. This is a felony case. It's 21 CP 203879. And it's still in the complaint room at the DA's office, Your Honor. It doesn't appear, he's on a $10,000 bond right now. It doesn't appear that he'll be getting out anytime soon. I don't know when he'll be getting out to complete his family violence intervention program, Your Honor. And to add, the victims no longer lives in Georgia. So for those reasons, Your Honor, I'm offering what I'm offering to this defendant.
And just to clarify, you're offering basically time served, balance suspended on which count?
Simple battery, family violence, one count. I'm no processing the rest. And no contact with both victims involved.
Okay. And Mr. McLean, I don't think you've had an opportunity to speak to your client about this particular plea offer. Is that correct?
Not the plea offer, Your Honor, but I was aware there was a case involving claim of damaged TVs, but I believe what the Assistant Solicitor General is saying, that would be something he would want to move forward on today if nobody has any objections. If the other court would be okay with us doing it here, that sounds to me like, per our discussion, that he would want to go ahead and do today.
Let me just confirm one thing over here. Criminal trespass. The criminal trespass is allegedly damaging the window of a tiara hood.
Right. I think that felony case mentioned may be the allegation of damaging two televisions, both of which he purchased.
No, I'm not addressing the television case. I'm addressing this case, which is the allegation that he damaged the window of one tiara hood.
That's the same victim in this case, Your Honor.
Okay. So do you need to speak to your client before we address the plea?
If he has any questions, I'd be glad to. Does he?
Courtroom 2, please unmute. Mr. Berry, you have a right to remain silent about the facts of the case. Anything you say, your statements can and will be used against you. Your attorney is asking you a direct question as to whether you have any questions about the recommended plea offer, or do you have any questions about the plea offer?
I was wondering, is this handle everything?
I don't understand what you're saying, sir.
I'm saying, this handle all my charges?
I don't understand what he's saying.
He says, are those charges? And the answer is really no.
This is not your cases in Superior Court. This is only the state court case arising from an incident in which allegedly Tiara Hood's window was damaged. It's nothing to do with televisions or anything to that effect.
I'm saying, is this dealing with the misdemeanor and felony charges?
No. Just the misdemeanor.
So we can't handle both of them right now?
This is state court. I don't have jurisdiction over Superior Court cases. All right. So, Mr. Berry, if you'd like to have a seat, Mr. McLean can call the jail to talk to you about whether you want to move forward with this plea.
All right, is that going to be the 2392 extension?
Yes, that is.
Yes.
Okay.
Next case, Francois?
We can go back to position 30, Mr. Richardson. Come on, Mr. Richardson.
All right, Mr. Howard, what would we like to do?
Mr. Richardson has indicated that he'd like to resolve this matter today. I just sent Mr. Long a chat to see if he would consider a plea to the less safe and merge in the per se. But he wants to resolve the case today by entering a plea.
All right, I will consider this right now a non-negotiated plea. So, Mr. Richardson, if you want to consider a plea, I will hear from the prosecutor first, and then I will hear from the defense, after which I will let you know which option I'm going to select. Mr. Long?
Thank you, Your Honor. So in this case, the state's recommendation is to plead to count 2, which is the per se DUI count. 12 months to serve, confined 28 days, credit for time served 14 days, balance probated, $300 fine, 40 hours of community service, risk reduction program, alcohol and drug evaluation and treatment, MAD impact panel, no drugs or alcohol. And we would merge count 1, which is the DUI alcohol less safe, into count 2. The reason that we're recommending this in this case is based on history, as well as the potential for reoffending. He does have an extensive criminal history, 14 cycles back to 2004. Some of the highlights are 2006, aggravated assault, aggravated battery, where he got 7 years confinement, followed by 8 years of probation. He also had a 2014, January of 2014, aggravated assault, criminal attempt to commit robbery case, where he also received confinement followed by probation. And he also has a recent August 8th, 2021 case for simple battery, criminal damage to property. And so I understand that the charges in this case are not of a similar nature to the prior record. He does have an extensive prior history. And as a result, we are concerned that he might potentially reoffend, and we feel that our offer is appropriate. In this situation, the facts were egregious because of the potential danger to other people. It was in a Waffle House parking lot where a Waffle House employee was observing the driver move the vehicle, then fall asleep with the foot on the brake with the car in gear repeatedly. So during that time frame, the potential that someone else may have been in the parking lot and could have been harmed at a Waffle House was high. And when the police contacted the driver or the defendant just told the police that he was trying to get some sleep. There was typical signs of impairment, and the breath alcohol level was 0.154 and 0.151. So for those reasons, we feel it's appropriate that he does plead to the per se DUI under count 2 with the conditions as stated.
All right, thank you. Ms. Harvey, since 2013, have there been any subsequent arrests or convictions for DUI?
No, Your Honor.
Thank you. Mr. Howard?
Judge, that was the only thing we were asking, that he plead to the less safe, and that the per se merge. Otherwise, we're in agreement with the terms, Judge.
It would be a guilty plea to DUI per se, and it would be a credit for time served, and he would be placed on probation to complete a $300 fine, 40 hours community service, a risk reduction program, alcohol and drug evaluation and treatment if required, complete 1 MAD impact panel, no illegal drugs and no alcohol, and count 1 will merge into count 2. And if he completes all the programs, I will put him on non-reporting probation.
Thank you, Judge.
All right, Mr. Richardson, this is the option I'm selecting. Would you like to move forward with the plea, or would you like to confer with your attorney?
Yes, ma'am. I would like to move forward. However, I wanted to point out that I had already
We
completed.
talked about that. Remember, Mr. Richard just turned it in. Just turn it in. Yeah. Yeah. Just turn it into probation.
Okay, but it's been so long. What if I'm unable to find, like, how would I find,
How'd you what now?
how would I find out how to turn it in if the place, you know, I was in prison for so long after this happened, the first time I've ever had a DUI, I was in prison for 7 years. And during that time, I don't know what happened to the DUI school that I went to. I don't know where the paperwork is.
All right, Mr.
Well, we can talk about that.
Just
Yeah,
one
we can talk-
second, just 1 second. If you completed a DUI school, what year was it?
It was in, if this happened, this was in 2014, right before.
Okay, so today you are pleading guilty to this offense in 2022 for a 2013 offense. I do understand you may have attended a DUI school. I understand that. But in order for you to challenge this charge today, you will need to go through the programs I've just. I'm not going to accept a school from that far back. Do you want to proceed, or shall I just arraign the case? I did tell your attorney that I'm going to put your probation non-reporting once you've completed all the programs, and I normally do not do that in a DUI case. So Mr. Richardson, you need to let me know whether you want to move forward or whether we can schedule the case for trial.
I'll plead guilty.
I'm sorry, I can't hear you.
I said I'll plead guilty.
All right. Mr. Howard, do you stipulate to at least the venue and the ID?
We do, Judge, but I do have a question about the, if I could, about the risk reduction, because we do have clients that once they get a DUI charge, will go ahead and take the initiative to get it done. Sounds like he did that. If he's able to locate that, even though, as long as it was after the offense date with the court, you know, allow him to turn that in, because he indicated he went ahead and did that in anticipation of resolving the case in 2014. So we would ask that he be given the benefit of doing that if he's able to find the proof of it.
So let me make this clear. I am not accepting that old DUI program. He's in jail because he did not appear in court.
Mm-hmm.
All right. So let's move forward. Do you want this? Is he going to do the program, or do we go to trial?
I think he's indicated he would do it, Judge.
All right, thank you. So are we stipulating to venue and ID at least?
Yes, Judge, we do.
Okay. So Richardson, if you want to move forward with this plea, I need to place you under oath. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Repeat. All right. Now, it's very important that I hear your response. If I cannot understand your responses, then I'm not convinced that your plea is going to be done freely, voluntarily, knowingly, and intelligently. Do you understand, sir?
Yes.
First of all, Mr. Richardson, are you under the influence of any kind of medication, drugs, or alcoholic beverages?
No, sir.
Are you satisfied with the representation of your attorney?
Yeah. Yes.
Is anyone forcing you or inducing you to take this plea, or are you taking this plea under duress?
No.
I'm having a hard time hearing. Okay, thank you.
I'm having a really tough time hearing him. Is anyone forcing you, inducing you to take this plea, or are you doing it under duress?
No, no one's forcing me, and I'm not doing it under duress.
Thank you. If you decide to plead guilty to the charge of DUI under the influence of alcohol per se, I'm sorry, South Annex, could we mute the screen, please? I'm sorry, South Annex, please mute. Thank you. Thank you. All right. As I was saying, Mr. Richardson, if you decide to plead guilty to that one count, you would have to waive your constitutional right to go back to court, to have a trial before a judge or a jury, to confront your accuser, challenge the state's evidence, present your own defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yeah. Okay. Yes.
How do you plead to one count of driving under the influence of alcohol per se? Your sentence is 12 months to serve 28 days, credit for time served 14 days. You'll be placed on probation, during which time you will pay a $300 fine, complete 40 hours of voluntary community service, complete one risk reduction program, alcohol and drug evaluation, and submit yourself to any treatment if required. You're also to complete one MAD impact panel. While you're on probation, you're not to consume any alcoholic beverages and no illegal drugs. Count one, DUI per se, less safe, will merge into the per se count. I will waive your probation fees for the first 4 months, which means up to and including end of April 2022. If you've completed all the necessary programs of your probation will then be non-reporting. That concludes this case.
Thank you, Judge.
Thank you.
Next, we have positions 5 through 8.
Just one second. Milton, you're next. Let me just address 3 South. 3 South,
Yes,
who do we have? 3 South, I'm sorry, who do we have?
Positions 5 through 8, Mr. Bryant.
Mr. Bryant, okay. Mr. Miles Bryant. Is represented by attorney, Mr. Mike McLean. Mr. McLean?
Your Honor, if I could, before we get started, as Your Honor is aware, this defendant has positions 5 through 8 on the calendar, some of which that were set for trial, and it is and this defendant has FTA'd on all of these charges. It's the state's position that these cases be transferred to the division judge, because we don't believe it's appropriate to consider lowering a bond on charges that the division judge has already set.
Okay.
And the dates for those failure to appears are January 27th, 2021, February 24th, 2021, October 5th, 2021, and November 4th, 2021. On one of those, which was a jury trial.
Oh, you mean those were the dates on which he was placed on a trial calendar?
No, those were the dates he failed to appear for the trial calendar. Yes, Your Honor.
I see. Okay. So unfortunately, I cannot move forward with this case until his attorney, Mike McLean, appears. Mr. Howard, any idea of Mr. McLean's location or ETA? All right, 3 South, please hang tight. I will address your case very shortly as soon as Mr. McLean appears on the Zoom. Mr. Mike McLean, sounding out for Attorney McLean.
Your Honor, Attorney Howard is on the phone right now.
Okay.
Okay, he's off now.
All right, South Annex, do you have any cases with Mr. Howard?
Yes, Your Honor.
All right, who are we going to address first? Deputy Milton, who are we addressing first?
The board leader writes position 26 is Ms. Molinax, and then position 34 is Ms. Justice.
Understood, thank you. All right, good morning. My name is Judge Lal, and with regards to both of you, I'd like to remind you that you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing both of you will be a member from the Public Defense Office. With regards to position 26.
It's actually 27, Judge.
Oh, 27, excuse me.
Okay, sorry.
No, that's all right, don't worry. We have quite a few cases, all right. Position 27, I am addressing, and I'm sorry, Tamara Lee Mullinex, and that would be, please raise your hand, whoever is Ms. Mullinex, okay. Ms. Mullinex, you are accused of 6 separate counts of criminal trespass in accusation case number 22 CR 000178H. Ms. Mullinex, your attorney is going to be Mr. Derek Howard. And Mr. Howard, I understand this is going to be a plea. Is that correct?
That is correct, Your Honor.
All right. Mr. Mullinex, Ms. Mullinex, excuse me. If you please raise your right hand, do you solemnly swear and affirm for the purposes of this plea that the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right, Mr. Long, what is the recommendation for counts 1 through 6 for criminal trespass allegedly at 1100 Caliber Creek Parkway in Roswell?
Yes, Your Honor. The recommendation for count 1 would be 12 months to serve, confined 160 days, credit for time served 81 days, balance probated, 12-week anger management, no drugs, alcohol, weapons, or firearms, stay away from Park 83 by Cortland Apartments, stay away from 1100 Caliber Creek Parkway in Roswell, MHET, no further contact with any of the victims, Shannon Fields, Christopher Fall, William Artley, Spencer Regas, Leslie North, and Christina Francis. There is restitution for Mr. Or for Miss Leslie North, $305.74, who's the count 5 victim. And then there's restitution that's not on the offer sheet, but we're adding, and I've informed Mr. Howard about this. Count 4 is $228.64 to Spencer Regas, R-I-G-A-S. Counts 2 through 6 would be 12 months probation, consecutive, but concurrent with each other to count 1, with the above same conditions extending into counts 2 through 6. Your Honor,
she'll be on 5 years of probation?
No, it would be 2 total years of probation. So counts 2 through 6 are concurrent with each other, but
I see.
consecutive to count 1. And Your Honor, the defendant does have an additional open case that I've spoken to defense about that we were prepared to resolve today. I did email Mr. Jordan, but it was only this morning. Would the court be okay entertaining that case as well?
All right, Mr. Howard, that's the second case, 21 CR 0053, excuse me.
It's 3 zeros, Judge.
3 zeros, okay.
Yeah.
000537H, involving the Caliber Creek Parkway, Roswell. Have you spoken to your client, and is this something y'all want to address at the same time?
Yes, Judge, I've spoken with her and she wants to resolve this one as well.
Okay, so we are also going to consider this case 21 CR 000537H, in which just pull that up. I do apologize.
Your Honor, for position number 27, and obviously I only show 4 counts of criminal trespass, not 6.
There should be additional counts that were filed later.
I don't see any additional.
Amended accusations were filed on January 14, 2022.
Yes.
And this was the trespass with regards to Leslie North, car windows. And the second one was for Christina Francis.
Yes.
I guess what happened, the clerk's office didn't add the charges, so it's just on 1 through 3.
Okay. And I do see the 4 accusations from January 12, 2022. All right, Mr. Jordan, Ms. Champion, we need to add the accusations that were already filed on January 14, 2022 to this case. So I do see the accusations. It's just a inadvertent mistake that we've not supplemented that to the charge count on this particular case. But with regard to the second case, which is How many counts are we looking at in that one?
Just one, and it's criminal trespass, damage to property as well.
So Judge, is there supposed to be 6 counts of criminal trespass?
In position 27, case ending in 178H, there are 6 separate counts of criminal trespass.
Okay, I'll add the other 2 charges to it.
Right. The first four charges were from the January 12, 2022 accusations. The subsequent two charges are from the January 14, 2022 amended accusations. Okay. All right. Okay, Mr. Howard, is that your understanding of what your client is facing?
That's correct, Judge. We discussed that last night. Yes.
All right. So in the second case, ending in 537H,
The state's recommendation on 537H would be 12 months to serve, 160 days, credit for time served, 81 days, balance probated, MHET, stay away from 1100 Caliber Creek Parkway, Roswell, Georgia, and that would be concurrent with count 1 of 22CR000178H.
so she would be on 24 months of probation for these 2 cases
Correct.
with restitution to 2 victims.
Correct.
All right. And to complete an anger management and an MHET as well.
Correct.
Yes.
All right. Mr. Howard?
Judge, the only thing that was different from what we discussed, and maybe I missed your email, Mr. Long, about the second restitution amount. I just needed to let Ms. Mullinax know that there is, what was the amount again? 20.
Yes, I did email you yesterday about the second restitution amount.
Yeah.
And it is for the count 4 victim of Spencer Regas, which is $228.64. And I did send you the documentation showing.
Okay. Yeah, I probably was in the jail when sent it. So Ms. Mullinax, you're okay with that as well? Okay, all right. So other than that, Judge, we stipulated venue ID. We asked you to accept the plea as negotiated.
And factual basis as well, correct?
Yes. Yes, Judge.
Ms. Mullinax, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
All right. You do understand these are 2 separate cases with a total of 7 charges to which you will be placed on probation for up to 24 months. And you would have to pay restitution to 2 separate victims. Payments will be made directly to your probation officer, and you do not have, and you have to stay away from the location and stay away from the victims for the next up to 24 months. Do you understand?
Yes.
All right. First of all, Ms. Mullinax, are you under the influence of any kind of medication or alcoholic beverages?
No. No.
Are you satisfied with the representation of your attorney, Mr. Howard?
Yes. Yes.
Is anyone forcing you to take a plea today, or are you doing so under duress?
No. No, it's for you.
And Ms. Mullinax, if you decide to plead guilty to these charges in case 22 CR 000178H and 21 CR 000537H, you will have to waive your constitutional rights to challenge these charges in a court of law. Specifically, you would have to waive your rights to go back to court, to have a trial before a judge or a jury, to confront your accuser, examine witnesses, present evidence of any defenses, as well as challenge the state's cases, and also to have the state try to prove the charges against you beyond a reasonable doubt. You would also have to waive your rights to argue your case before a judge or jury and possibly being acquitted of these charges. Are you prepared to waive your rights?
Yes.
In case ending in 178H, how do you plead to the 6 counts of criminal trespass?
Guilty.
In the case ending with 537H, how do you plead to the 1 count of criminal trespass causing damage to property?
Guilty.
On count 1, your sentence is 12 months to serve 160 days, credit for time served 81 days. Your time at the jail is concluded. You'll be released within 24 hours to report to probation. You have up to 48 hours to report to probation. Once you're placed on probation, you have to complete a 12-week anger management program, not consume any illegal drugs, no alcoholic beverages, and you're not allowed to possess any weapons or any firearms. You are to stay 200 yards away from the entire location identified as 83 by Cortland Apartments, as well as stay 200 yards away from the entire complex identified as 1100 Caliber Creek Parkway in Roswell, Georgia. While you're on probation, you will also complete an MHET, which means that once you complete the evaluation, you would need to submit yourself to any treatment as recommended. During the remainder of the 24 months probation, you are to have no contact with Shannon Fields, Christopher Fall, William Otley, Spencer Rigas, R-I-G-A-S, Leslie North, and Christina Francis. While on probation, you're also to pay restitution of $305.74 to Leslie North, payment to be made directly to your probation officer, and restitution of $228.64 for Spencer Rigas, payments again to be made directly to your probation officer. For counts two through 6, the sentence is 12 months. Those counts 2 to 6 are concurrent, but they are consecutive to count 1, which therefore places you on 24 months of probation. And the sentence is to continue with the conditions I've just articulated. With regards to the second case ending in 537H, your sentence is 12 months. It's going to be consecutive. It's going to be concurrent to counts 2 through 6 and consecutive to count 1 of the previous case. And the sentence is 12 months to serve 160 days, credit for time served 81 days. Also to complete the MHET as required, and to stay away from 1100 Caliber Creek Parkway in Roswell, Georgia. In conclusion, Ms. Mullinex, you're basically to stay away from all the victims I've identified and stay away from the 2 properties I've identified for up to 24 months. Understood? All right. You will continue to report to probation every month for up to 24 months. I will waive your probation fees for the I will waive your probation fees for the next 12 months. All right?
Thank you, Judge.
All right. Anything else?
Nothing
Nothing
further.
further, Judge.
All right. Thank you, folks.
Thank you.
The next position was position 34 at the South Annex, and this is this Justice Upton? All right.
Yes.
Ms. Justice Upton is accused of theft by shoplifting in case 20 CR 005-738Y. And Ms. Upton, you've been advised of your right to remain silent. Your attorney is Mr. Derek Howard. Is this going to be a negotiated plea, Mr. Howard?
Yes, Judge.
All right. Ms. Upton, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Long, what is the recommended sentence?
Yes, Your Honor, it is 12 months to serve, confinement 14 days, credit for time served 14 days, stay away from 3030 Headland Drive Southwest, which is a shopping center, balance probated, theft awareness, $150, and we have no objection to term of the probation after the fine and the theft class are completed.
All right. So instead of the community service, you are imposing a $150 fine. Is that correct?
Yes, it was renegotiated.
Okay. And non-reporting after completion?
We had no objection to termination.
Oh, termination. I'm sorry. Okay.
After completion.
Oh, thank you.
Thank you.
Mr. Howard?
Yes, Judge. I didn't get a chance to tell Ms. Upton, but Mr. Long was gracious enough to change it from the community service to the 150 that you had negotiated, Mr. Borger. So they were okay with that. But otherwise, we would stipulate the venue ID and a factual basis for the plea, Judge. We'd ask that you accept the plea as negotiated.
Ms. Upton, are you under the influence of any kind of medication or drugs?
No.
All right, and are you satisfied with the representation of your attorney?
Yes.
If you decide to plead guilty to the theft by shoplifting, you would have to give up your right to go back to court, to have a trial before a judge or a jury, confront your accuser, have the assistance of counsel to present your defenses or challenge the state's case, and also have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of theft by shoplifting?
Guilty, Your Honor.
Your sentence is 12 months to serve 14 days, credit for time served 14 days. You'll be released within 24 hours, and you have up to 48 hours to report to probation. Once you're on probation, you're to pay a $150 fine, and you are to complete a theft awareness class. The class and the program will be recommended by your probation officer. Once you've completed the class and paid off your fine, your probation will terminate. You will report to probation every month until you completed the programs and paid off your fine, and your probation fees will be waived for up to the first 2 months, including up to the end of March of 2022.
I had a question. Will I get paperwork receiving where I need to report to or who my probation officer is?
Yes, you will.
Okay.
Anything else, Mr. Howard?
Nothing further, Judge.
All right, thank you. Mr. Law?
Did you announce the stay away, Your Honor? I might have missed it.
Oh, sorry, no, I didn't. You need to stay away from the entire shopping center at 3030 Headland Drive in Southwest Atlanta.
Okay.
So do not return there, otherwise you'll be arrested for criminal trespass.
Thank
All
you.
right, thank you. Okay, I'm sorry, I'm going to go to position 21. Mr. Sedeno is present for us to provide translation services.
Good morning, Your Honor.
Good morning. I'm sorry, Mr. Lombardi is present in courtroom 2.
Bien. Señor Lamberto, se encuentra presente usted en el juzgado número 2, ¿no?
Yeah.
Yes.
This
Yes.
is, thank you, Mr. Sedeno. Do you solemnly swear and affirm the translation you provide will be a fair and accurate translation with no changes or embellishments?
I do.
Thank you.
Thank you.
Mr. Lamberto is his first name. His last name is Marcio. His case number is 21 CR 007-588H, accused of criminal trespass.
Bien, nos encontramos aquí con el señor Marcial Lamberto.
Judge, before we go any further, I don't believe Mr. McLean is on the screen. Is he in a breakout with someone? Because this is his client.
All right. Mr.
Mr.
Sedeno, continue translation and we'll wait on Mr. McLean.
Bien, este es el señor Marcial Alberto con el caso número 21CR007588H, siendo acusado de allanamiento de morada.
Mr. McLean's in the courtroom.
Oh, okay. Okay. All right, great. I didn't know he made it in. Okay.
He's traveled more during the pandemic shutdown than I have. So. All right. Mr. Sedeno, could you please advise Mr. Marcel that his attorney is in the courtroom? And
Señor,
go ahead.
Señor Marcial, la juez le quiere informar que su abogado está aquí en el juzgado.
Right. And that his attorney, do you have the screen on?
I could go back into Zoom, Your Honor, and join the breakout room.
Right there, fellas. Come on.
This will take a second.
Ms. Jordan, Mr. McLean is going to join through Zoom. I don't know why the screen is not. We don't have the visual in the court.
Right, these screens are not on.
There seems to be a glitch. All right, Mr. McLean, while you are present, Mr. Sedeno, let's advise Mr. Marcial that he has a right to remain silent about the facts of the case. Any statements he makes those could be used against him. He has the right to an attorney, and his attorney, Mr. Mike McLean, is representing him and will appear very soon on the screen in front of you.
Bien, señor, yo le quería informar a la juez de que usted tiene el derecho a permanecer en silencio. Cualquier cosa que usted diga puede y será utilizada en su contra. También tiene el derecho a tener un abogado. Su abogado es el señor McLean y se está conectando en este momento a la plataforma de Zoom.
Are you in, Mr. McLean?
It's saying host is living in. Yeah. There we go.
Okay.
Continue.
Recording in progress.
All right. So, Mr. You can please. Yeah, okay.
I can't completely eliminate the audio, but I can get it down to about 2%.
Okay, that's good. Mr. McLean, your client has been advised of his right. How would you like to proceed today?
Le dice que su cliente ha sido ya informado de sus derechos. ¿Cómo quisiera proceder de su parte, señor McLean?
Okay. Mr. McLean, you're going to have to repeat your response because the translator was relaying the information to your client.
I just need to convey the offer to him in the breakout room.
Dice, necesito hablar con él sobre la oferta que le han hecho y necesitamos irnos a la habitación virtual, al cuarto virtual.
The way you can communicate with your client, Mr. McLean, is that you'll have to step outside and contact the jail. Well, we're going to have some difficulty.
I can do a breakout room for him, Judge, if he goes outside.
Okay.
2397.
But we'll have to place courtroom 2 in a breakout as well. Let's do court 3 South. Who do we have in 3 South?
Positions 5 through 8.
Okay. Courtroom 2, we will talk to Mr. Maciel very shortly. I need Mr. McLean for positions 5 through 8 at present time. Okay. Hold courtroom 2. Okay, Mr. McLean, on 3 South, we have a client of yours, Mr. Miles Bryant. All right. Mr. Bryant, you has been advised of his right to remain silent, and his attorney is Mr. Michael McLean. And Ms. Duncan, now that Mr. McLean is present, could you repeat your request again?
It is the state's position that these cases be transferred to the division judge. This particular defendant has 4 cases before the court today, positions 5 through 8, and at least all of which have been set for trial or plea and arraignment, and the defendant has failed to appear on all of those charges. Then that is the basis for the bonds that are set today. So the state feels it would be inappropriate to readdress or consider a bond in place of the division judge who set these bonds due to the failure to appear for jury trial and plea and arraignments on the dates as follows: January 27th, 2021, February 24th, 2021, October 5th, 2021, and November 4th, 2021. The position 5 was set for jury trial in front of Judge Edie, and the defendant failed to appear. The others were set for plea and arraignment, and the defendant failed to appear as well on those.
Did you hear that, Mr. McLean?
I caught most of it, Your Honor. The situation is that his mail should work, and he had himself and a family member called in to the clerk's office. They were told they had not missed a court date, but a week after he did miss a court date, I believe it was December the 13th, he says that his bonding company called him. And therefore, he immediately planned to come to court and amassed, he worked some overtime that week. It was during the Christmas holidays coming up right then after that week, so that he was in a position where he needed to leave some money at the household. He was going to turn himself in. And indeed, he did that. I wish he had turned himself in the day they called him on the phone, but he had the thought that the household needs money. I need to work some overtime this week. I need to put them in a position where if I don't get out immediately from jail, I'm going to go turn myself in.
but they need to be able to not be thrown out on the street. And I understand completely that. I wish he had called somebody else, and by turning himself in immediately, it might have even been better. So he did turn himself in. I believe it was approximately early January.
If he surrendered himself, it was on January 10th, 2022,
10th?
which is more than 2 weeks.
Right, exactly. And so I said, the timing's bad because a better thought would have been to jump on the legal part of it and talk to us immediately rather than, the turning yourself in is a great idea. It's a very noble and very conscientious thing to do. And he did. But he did fear that his family was going to be thrown out on the street if he didn't work some overtime and make some money for them real quick. He also felt that the dead week, which is generally speaking a dead week between Christmas and New Year's, he knew there wouldn't be anybody around to process him or consider his plight. So he would ask the court.
Just 1 second. Can you hear Mr. McLean, Ms. Duncan?
Yes, Your Honor.
All right. Anything else to add, Mr. McLean?
So he basically asked the court to return him to a position of freedom on bond. He understands that he can come down here every 2 weeks, use the public computer on the counter in front of the clerk's glass windows, doesn't have to rely upon the mail to not miss a court date. He really didn't do it on purpose, and he would not miss a court date if he could possibly show up in court.
Oh, thank you. Now, Ms. Duncan.
Your Honor, the state would just like to clarify for position 6 in particular. Well, overall, he has FTAs dating back to February 2021, but for position 6, he failed to appear twice, once in February 2021, and then again in October 2021, and then the other charge was a failure to appear from January. So he's continuously failed to appear over the span of the entire year of 2021. And it's for those reasons that the bond was set as such by the division judge. So we remain that our position is these should be transferred to the division judge as to appropriate the bond and things of that nature, since that is the reason why they were set as such.
Okay. Mr. Miles Bryant, okay, first of all, I agree with your attorney that you did surrender yourself back to the jail for not showing up in court when summoned. That's good. And if it was just one case, and if this is your first or second infraction, I could perhaps find grounds to set aside the bench warrant and not have let Judge Edie go ahead and place you on the trial calendar in the future. However, this is case 17 CR 021508Y, in which you've been accused, among other charges, carrying a weapon without a license and discharging a firearm on a public highway in reckless conduct from 2017. 19 CR 008770Y, you've been accused of simple assault, domestic violence, and criminal trespass, domestic violence from September 2018. Case 19 CR 008793Y, you've been accused of battery, domestic violence from March 2019. Case 20 CR 001075Y, you've been accused of DUI, reckless driving, and driving while suspended in 2019. This have been 4 consecutive infractions with the law, and you do have a history of failure to appear, and I'm afraid that your record does not support any modification of your bond. The bonds on the bench warrants shall remain as is, and your cases are going to be transferred to Judge Edie's division to be placed on a trial calendar. Thank you.
Thank you, Your Honor.
Mr. McLean.
Nick.
All right, Mr. McLean, if you want to go and step outside, Mr. Jordan will place Mr. Cedeno, courtroom 2.
I got position number 14, Mr. Johnson.
14, is that Mr. Howard's case?
Oh, that's Mr. McLean's case as well, Judge. 14.
Judge Law, it's position number 25 of Mr. Marcel. Is he supposed to be on the breakout for an interpretation?
Yes, just courtroom two with Sedano. Needs to
Yeah,
be
we
in a
haven't did,
breakout.
they haven't did the breakout
Nope.
yet.
All right. 3 South, we have concluded with Mr. Bryant. This case is going to go back to Judge Edie's division.
14.
Mr. McLean is in the breakout. Do you have any cases after? Where does you all start, Mr. Howard?
Judge, 20 after 21, position 29 and position 33 are mine. That should be on for pleas.
Okay, they're in courtroom 2.
Oh, they're both in courtroom too.
Yes, they are.
Okay,
Maybe they can
29. 29, let's do 29.
Okay, have a seat for me over on this side. Come on, Mr. Palmer. Palmer, come on, hurry up.
Mr. McLean, please call, oh dear. Yeah, I can't place you in the breakout because Mr. Howard's clients are in courtroom 2.
Your Honor, should we do a three-way conference call? Because I can perhaps do that if you give me the phone numbers to call. I can call Mr. McLean in courtroom 2, if that's easier for the court.
It is. Did you get that, Marcelo?
No, I'm sorry. I didn't hear.
Digit by digit. 770.
770? I can't hear. Sorry.
He needs to walk up closer to that mic.
770-842.
842?
5471.
5471. And
the jail is 404-612-2392.
Okay, I'm going to call right now.
Thank you, Marcelo. Truly appreciate it.
My pleasure.
5471. Yeah. Thank you. Courtroom 2, we have, I'm sorry, position 29.
29, Mr. Palmer.
Okay. Derek Palmer is case number 21 CR 008011B and accused of simple battery from a December 29, 2021 incident. Mr. Palmer, you've been advised of your right to remain silent, and your attorney is Mr. Derek Howard. Mr. Howard, are we still proceeding with a negotiated plea?
Yes, Judge.
All right. Mr. Palmer, if you please look up and raise your right hand. I need to see your face, sir. Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Let him pick it up.
Yes.
Is your name Derek Palmer?
Yes.
All right. Thank you. Mr. Long, what's the recommendation for Mr. Palmer?
The recommendation is 12 months to serve, confined 60 days, credit for time served 22 days, balance probated, no further contact with Dimery Bell, that's spelled D-I-M-E-R-Y, Bell common spelling. Stay away from 1122 Perimeter Center West, Atlanta. No drugs, alcohol, or weapons, 40 hours of community service, and 8 weeks of anger management.
All right. Mr. Howard?
Just that's our understanding of the negotiation. We'd ask that you accept that. We would ask for some consideration on the probation fees, given he's not currently working. He'll certainly have to find employment to be able to do the 8 weeks of anger management, but we stipulate the venue ID and a factual basis for the plea.
And does he have a confirmed mailing address?
He does not, Judge. The Atlanta Union Mission is where he indicated he's going to go once he's released. The address for them is 156 Mills Street, M-I-L-L-S Street, Northwest, Atlanta 30313. He indicated he's been in that particular shelter before, so that's where he plans on going once he's released.
All right. Does he have any holds? I see there's a case ending with 47.
Let me see, Judge. I was thinking, is that holding him in jail? Let me just confirm, Judge.
Looks like it's a citation. There's no warrant.
For that, are you talking about 20 COV ending in 47?
Yes, it's got a ORCA hearing on February 23rd. I don't.
Let me see if this holding him, Judge.
Yeah, it looks like an
Right,
open.
it doesn't appear that's holding him in jail, Judge. Well, no, I'll take that back. It does. Okay, so yeah, that 19 CR simple battery. Yeah, Mr. Long, we may need to. Yeah, Judge, we were thinking this would resolve his issues, but there is the second simple battery case that's not on the calendar.
I think there's 2 other simple battery cases open.
I think the second one may be closed.
I'm showing a 19 CR 008711B.
Oh, that's a bench warrant.
And I'm also showing for FTA, and then also showing the other COV case.
Okay. So Mr. Howard, he's got case 19 CR 008711B.
Yes, I do see that now. So we may want Judge to maybe reset these to Tuesday to deal with both of these, unless the state, I would need to break out, because we talked about his other case on last night, but it wasn't on the calendar. I guess I thought maybe he was not being held on that.
All right, so let's clarify. He's got 19 CR 008711B, accused of simple battery from October 23rd, 2019.
Yes.
He's got a bench warrant issued in that case. Warrant was issued on September 16, 2021.
Correct.
And I think he's got a $1,500 surety bond in that case.
Yes.
All right. In the present, and that's the case that we have right now. In the other case, 20 COB, 000047. He's accused of simple battery from April 9, 2020. And he's got a court date on February 16, 2022. And I think he's got a $2,500 surety bond in that one.
I had arraignment February 26th for some reason. I'll have to look.
Maybe a typo. I'm looking at the calendar, is February 16.
Oh, it must be a typo.
Okay. So these are the 2 cases that I see with regards to Derek Palmer. Mr. Howard, shall I reset? Well, one case has already got a date on February 16.
And let's see, Judge, if the state, we may want to just reset each of those to Tuesday. If the state wants to, obviously we'll need some information from the state on that, and then we may be able to resolve all 3. If not, then the date will remain for the February court date, but we may be able to resolve that one as well, depending on the state's recommendation.
I'm going to reset this case to next Thursday. Well, no, I'll do it Tuesday, sorry. Okay for Tuesday.
Yes.
How are we looking, April, for Tuesday, 25th?
Yes.
Yeah, we're okay. We're okay. We can do it. All right, we'll reset the case to January 25th, 2021 for a possible plea, at which time the state can also consider 20 COB 000047 unless they're just absolutely set on the February 16th date, which is pretty much going to be the same proceeding as what we do at SAP.
And Your Honor, sorry to interrupt, but I would actually prefer that you put him on Thursday if you're going to be the presiding judge on Thursday.
It's actually going to be Judge, what day is today? Yeah, it's going to be actually Judge Mincy.
Okay, well, I digress then. I just thought it would be more sense if we kept it with you, but you're not going to be here.
No, I won't be. I won't be the presiding judge that day. It will be Judge Mincy. So,
Okay.
so unless you want to do it the following Thursday. But then-
No, because I mean, we're not making any guarantees on the other case, but he does have at least 8 more days on this case. So.
Okay,
it's
so let's do it till the
okay.
25th. Is that all right, Mr. Howard?
Yes,
All right.
Judge.
Derek Palmer, his case is reset to January 25th. I'm not changing the Orca court date, but I'm just saying that Mr. Long and Mr. Howard, you all can consider that that COV case as well. If then arrangements made between the both of you.
Yes, Your Honor.
All right, thank you.
Thank you.
Okay, courtroom 2, do you have any
Carmen,
other
have a seat
cases?
over there for me. I'm sorry, who you asking for, Judge?
Any other cases involving Mr. Oh, do we, Sue, we have Miss Jeffrey from Raymond Gudich's office. And who was your client, Miss Jeffrey?
Alexandra Lagoras.
It's number
We don't have
18.
any-
I have it right here.
Here,
All right, thank you.
position 25. Come on, Mr. McGuire.
I want to do her case now. I got it right here. Number 18.
Wait, say the name again. Did you say Isaac McCuller?
Yeah.
Alexandra Laguros is in medical, so we'll be in courtroom 2 shortly. All right, we have Alexandra Laguros, and Miss Laguros, I'm sorry, am I pronouncing your last name correctly?
Yes, Lagoras.
All right. Ms. Laguras' case number is 17 CR 027-038Y. Ms. Laguras, my name is Judge Lal, and we are addressing your case that's already been accused. You have a right to remain silent about the facts of your case. Any statements you make, your comments can and will be used against you during the course of this virtual and recorded proceeding that's also live streamed. You have a right to an attorney, and representing you is Ms. Beth Jeffrey, and she is present on the Zoom as well. Ms. Jeffrey, if you don't mind waving your hand at the Zoom so she can spot you. Do you see your attorney?
I do, yes, ma'am.
Thank you. All right. In addition to multiple counts for DUI, Ms. Laguras, do you want me to list the offenses, Ms. Jeffrey?
No, Your Honor, she actually has already, a waiver of arraignment was filed on November 13th, 2018.
Judge, if I may briefly interject, there appears to have been some discussions between private counsel and the solicitor who has had the case, Max Borger, regarding what the bond should be set at. I'm not sure if there's also been consultation with Judge Edie already in regards to setting a bond, but I feel like the case may be more appropriately handled by Judge Edie if he is the division judge who has had the case due to the bonds being currently set the way they are after 2 FTAs for jury trial.
Just 1 second. These accusations were entered on December 15th and 20th of 2017. A waiver of arraignment was filed on November 13, 2018. So the case was further noticed for trial for Judge Edie. Notices were sent out on October 25th, 2021. Discovery request was submitted on October 28th, 2021. On November 16th and November 30th, we had notices sent back to the court. And this was to a Henderson Mill Road location.
The Henderson Mill Road location was her previous attorney, Mr. Price. And because this case had been pending so long, during the pendency, Mr. Price retired.
And then we have, no, excuse me, and then we have another one to a Jennifer Oak Circle location.
And that was her previous address. We have filed an entry of appearance in this matter, as well as a change of address with the clerk's office. So the clerk does now have her current address.
Yeah, all submitted after. All right. So now the defense has also filed a motion for a bond. And so, Ms. Jeffrey, I do apologize that you've been waiting this length of time, but the SAP calendar is generally for cases that have not been arraigned yet. That's why it's the plea and arraignment calendar. In your particular case, since you've waived arraignment, the matter should be addressed by the division judge, which is the protocol for these calendars.
All right, Your Honor, it was my understanding you could address a matter as to bond. She does have a bond, it's just that it's a cash-only bond, and that's the only thing we're trying to adjust is to shift it to any good bond.
I understand. But like I said, the protocol is that if the cases have not been arraigned or if that no waiver has been filed to date, I can address that. But as a protocol matter, and I'm sorry, I don't know if you've dealt with us judicial officers, unless I have express consent from Judge Edie's division to address a case that's already been arraigned or arraignment has been waived, I have to defer to the division judge.
All right, thank you, Your Honor. That motion is pending in front of Judge Edie now, so.
Okay.
All right.
I would recommend you contact Judge Edie's case manager and have this matter scheduled on the trial calendar. Mr. Long, do you know who is the ASG assigned to Judge Edie?
It's Max.
His name, Max Borger. I might be mispronouncing it.
All right, if you want to reach out to Mr. Borger. Mr. Gurus, your case will be scheduled before the division judge since this case has already been arraigned and it has to be handled by that particular judge. Thank you.
Next, Judge, we have position 15, Jones.
This is probably Mr. McLean.
15 is Mr. Jones, and
Okay.
I've been informed, he said that he could resolve the case today, Your Honor. Let me get over by the microphone.
All right.
Mr. Jones could resolve today's case if it included a certain other case, but I've been informed that that other case is designated as a felony. The paperwork has been a bit confusing. It started off as a misdemeanor. He had thought it had been kicked back as a misdemeanor, but he may be incorrect in that. It's a terroristic threats misdemeanor that apparently became a terroristic threats felony, and it may not have reverted back to being a misdemeanor yet.
All right. I really wanted to get back to Mr. Marcial's case.
Oh, sure.
But let's just, since you've already articulated your concerns in Mr. Jones' case. Mr. Jones, your case number is 21 CR 004272C. You're accused of battery, domestic violence with respect to this case from July 7th, 2021. From what you've been advised of your right to remain silent, and your attorney is Mr. Mike McLean, as you can see him on the screen. Ms. Duncan, is there another open case against Mr. Jones, and has the state transferred that to Superior Court?
Your Honor, it's my understanding that the terroristic threats charge is a felony.
Okay. Was it always initiated as a felony?
Apparently it was initiated as a misdemeanor, but since has been moved up to felony court.
All right. So Mr. Jones' position, we have one case that is a misdemeanor, which is this one. And he has another case, which is in Superior Court of Fulton County. This is state court, but you have a felony case in Superior Court. So given this information, Mr. McLean, what would you like to do in this particular case?
I'd like to call him and ask if he wants to go forward on this case, or whether it would be better if he waits about a week and asks for a reset.
Mr. Jones, what would you like to do?
I'll wait for the reset.
All right. And so this case is going to be reset to January 27th, 2022 for a plea. You can find out what's going on.
Right. That'll give us a chance to really delve into it and make sure everything's clear. We appreciate that.
All right. Thank you. Thank you, Mr. Jones. Going back to position 21 CR 007588H, State versus Lamberto Marcial. Mr. Marcial, the interpreter, and Mr. McLean have been in conference. Go ahead, Marcelo.
Bien,
vamos
a llamar su caso, señor, que es Marcial Lamberto, con número de caso 2100075888. Su abogado y el intérprete han estado en comunicación.
And Mr. McLean, I'm sorry, I didn't mean to stop you, but I just wanted to let Mr. Marcelo do his bit first. Okay.
I apologize. He does need to translate, and I need to wait while he does that.
how are you proceeding in this case?
It is a negotiated plea today, Your Honor. I've gone through the plea statement,
We're gonna
roughly.
pause for a minute. Go
Sure.
ahead, Marcelo.
Bien, su abogado está diciendo que hemos llegado a una negociación y que él se va a declarar. Tenemos ya su declaración de culpabilidad.
He has indicated to me through the translator that he understands all those questions and has the answers to those questions that I, by my experience, know are the appropriate answers that gets through a plea. In other words, he understands the trial process. He understands there won't be a trial. He understands his rights.
Oh, and then we're going to pause.
Bien, entonces él me ha indicado, yo quiero también indicar que él entiende y entendió todas las preguntas que yo le hice con respecto a sus derechos. También que él respondió todas las preguntas cuando estábamos llenando la solicitud para declararse culpable. Él entiende que no va a tener un juicio, él entiende que no va a pedir a la fiscalía que pruebe que es culpable más allá de una duda razonable.
He tells me no one is forcing him to do this or promising him anything, and it appears to be an order. I did emphasize to him the two warning questions toward the bottom of the page, that this could affect some other probation somewhere, and he says he understands.
Bien, entonces yo quiero también enfatizar que nosotros hablamos en detalle sobre su caso y cómo esto le puede afectar en el futuro, y él entiende porque hay dos avisos en la parte de abajo del documento en donde le indican a él de que su probatoria puede ser revocada.
And in particular, I mentioned to him, I said, you know, if you have an immigration question, you should address it to an immigration lawyer, because we are not immigration lawyers and cannot give immigration advice. And I encouraged him to seek that avenue.
Y en particular, yo le he dicho también que yo no soy un abogado de inmigración, que esto puede afectar su estado migratorio, pero que yo no le puedo aconsejar al respecto, pero él me ha dicho que él entiende eso.
I also expressed to him concern that I thought I saw an open case on his criminal history from March of 2021 that was a trespass case, and it didn't look to me like it had been taken care of.
También yo le he informado a él de que él tiene un caso abierto, que este caso abierto que él tiene puede también afectar.
But at least it's a misdemeanor. Does the state have any insight as to whether that's going to be a problem, or can we do it all?
Pero es un delito menor. No sé si la fiscalía puede indicarnos si esto va a ser un problema o si podemos continuar tal cual.
We can do both cases if the court is okay with that.
I am. I just need to have that identified.
Bien, necesito identificar esto.
It is case number 21 CR 001403Y.
Este es el caso 21 CR 0005Y.
So, Mr. Long, you are prepared to offer a plea recommendation in both these cases?
Yes.
¿Usted está dispuesto, dice, a hacer una recomendación para ambos casos? Sí.
And is Mr. McLean?
I note that the case ending in 03Y also has a count of obstruction. So I don't know if the state plans to null process that or just do a concurrent offer.
Yo sé que con otra acusación hay una acusación de obstrucción. No sé si pueden hacernos una oferta o puede ser algo concurrente.
It would be a concurrent offer as charged.
Va a ser una oferta concurrente tal como ha sido.
Sounds like a plan to me.
Bien, suena bien.
I think we can do this.
Entonces creo que podemos hacer esto.
Mr. McLean, have you discussed this plan with Mr. Marcio?
Yes, I expressed to him that I thought it was probably the same address. Is that correct?
That is correct.
Entonces yo hablé también con él, dice, y yo le dije que yo pienso que es la misma dirección en la que ha sido acusada 2 veces.
So we have sufficiently discussed those facts in that sense, Your Honor, because he does understand that it's very important for him to stay away from Irwin Street.
Nosotros hemos discutido esto y él entiende que es muy importante que se mantenga alejado de esta dirección.
And to not argue with the police if they are asking him to be cuffed.
y que no discuta con la policía si es que le piden que se vaya.
Mr. Lamberto Marcial, are you prepared to go forward with a possible guilty plea in both your cases?
Señor Lamberto Macías, ¿usted está listo para declararse culpable en ambos casos?
Sí.
Yes.
Please raise your right hand. Do you
Levante su mano derecha, señor.
solemnly swear and affirm that the testimony you provide in response to the questions made to you will be the truth and only the truth?
¿Usted jura que la declaración que dará en este caso pendiente será la verdad y solamente la verdad?
Sí.
Yes.
Mr. Long, we are addressing both these cases, 21 CR 0075888H. He's accused of criminal trespass at the Old Wheat Baptist Church in Irwin Street, allegedly on December 15, 2021. We are
Bien.
also addressing, I'm sorry, go ahead.
Entonces nosotros estamos aquí con el caso número 21 CR007588H, en donde él lo acusan de haber allanado la morada del Old Wheat Street, que es la iglesia que está en la calle Irwin.
We are also addressing a plea recommendation in case 21 CR 001403Y, accusation for criminal trespass and obstruction of an officer from a date of March 23rd, 2021.
Bien, entonces nosotros también estamos llamando el caso número 21 CR001403Y, que lo están acusando también por allanamiento de morada y también por obstrucción de la policía.
And Mr. Long, briefly, what is the recommendations for both cases?
It would be a concurrent 12 months to serve, confined 60 days, credit for time served on both cases 37 days, balance probated, stay away from 371 Irwin Street Northeast, Atlanta, which is the Old Wheat Baptist Church, drug and alcohol evaluation and treatment, 40 hours of community service, no drug, alcohol, or weapons.
Bien, la recomendación es concurrente, son 12 meses para que esté encarcelado 60 días, que pase en la cárcel los 37 días que ha pasado, son suficientes, el balance va a estar bajo probatoria, debe mantenerse alejado de la dirección 375 Irwin Street Northeast en Atlanta, que es la Old Wheat Baptist Church. Mientras esté bajo probatoria, tiene que hacerse una evaluación de drogas, alcohol y tratamiento si se recomienda, y 40 horas de servicio comunitario. Ok.
Mr. McLean, do you stipulate the factual basis, venue, and ID for both cases?
We do, Your Honor. Technical correction, it is the Old Wheat Street Baptist Church.
Old Wheat Street. Okay.
Bien, nosotros estipulamos que las bases son factuales.
But he understands the initial offer, it's the same as the offer being added concurrently, and so he asked the court to accept that as a negotiated plea.
Entonces él acepta y entiende que las dos sentencias son concurrentes, así que nosotros sí queremos pedir al tribunal que acepte lo que se ha negociado.
He understands. I'm sorry. He understands about the evaluation. It's going to be important for him to go seek that evaluation.
Él entiende la evaluación, es importante que él vaya a buscar esa ayuda.
And you've stipulated to factual basis, venue, and ID.
Yes, Your Honor.
De bases factuales, sí.
Ms. McLean, where does your client live, or does he have a verifiable mailing address?
That we did not, in the interpreted session, we did not get into that. So I don't have an address for him.
La juez está preguntando que si usted tiene una dirección estable donde nos podamos comunicar con usted. Su abogado dice que no hablamos de eso cuando estuvimos con el intérprete.
No tengo.
I don't have one.
Probation will need an address for him to be placed on probation.
Los de probatoria van a necesitar una dirección cuando usted esté yendo a probatoria.
Okay.
Okay?
Está bien.
That's fine.
We could ask if he uses a mail system of one of the churches on Peachtree Street, such as St. Luke's or one of the others.
Podemos preguntarle si utiliza algún sistema de correo o alguna de esos lugares que están, por ejemplo, en la St. Luke Street o ese tipo de cosas.
But not Old Wheat Street Baptist Church.
No, pero no en la Old Wheat Street Baptist Church.
Ms. Trina Harris, what does probation do with individuals who are residentially challenged with no mailing address?
That's actually going to be hard for us to even keep in touch with them due to that.
we will have no way of keeping in touch with them.
Nosotros no vamos a poder, dice la persona probatoria, que no nos podemos mantener en contacto con ellos sin una dirección, así que ellos tendrían que hacerlo.
Mr. McLean, we need to have a mailing address in order to place them on probation. Otherwise, it's a sentence in which they would possibly fail.
Necesitamos tener una dirección que entonces podamos poner, si no, no vamos a tener problemas con la sentencia.
Understood. If I could have Marcelo call us again on the conference call.
Sure.
Okay, go ahead. Mr. Marcel, you need to go back until we get your mailing address. Do we have any other cases for Mr. McLean in courtroom 2?
Judge, we also have another interpreter case, Mr. Martinez,
Okay.
Martinez.
Let's place Mr. Marcial on deck and let's address Mr. Martinez. Is that your client as well? Mr.
No, Your Honor.
Come on, sir.
Mr. Martinez?
Yes, Judge, Mr. Martinez was not available when we tried to visit him on yesterday. Looks like he's gonna need an interpreter anyway. But we're probably gonna be looking at a reset to Tuesday for Mr. Case. We tried to see him yesterday.
Marcelo, did you get that information for Mr. Conrado Martinez Guneta?
I'm sorry, Your Honor. May I confirm you said that his case will have to be reset for Tuesday?
Yes, this is Mr. Martinez Guneta, case number 18 CR 003089G.
Bien, este es el caso del señor Martínez Pineda. El número de caso es 18 CR 003089G.
He's accused of failure to maintain lane, hit and run, and driving without a valid license.
A él lo están acusando por no mantenerse en el carril y por manejar sin una licencia válida.
He has the right to remain silent. Anything he says, his statements can and will be used against him.
Tiene el derecho a permanecer en silencio. Cualquier cosa que diga puede y será utilizada en su contra.
And he has a right to an attorney. Representing him is Mr. Derek Howard.
Y tiene el derecho a tener un abogado y representando los encuentros del señor Derek Howard.
His attorney has not had time to consult with him and is requesting the case be reset to January 25th, 2022 at 9 a.m.
Entonces, su abogado ha dicho que no ha tenido tiempo de hablar con usted, así que está pidiendo que le den una extensión el 25 de enero a las 9 de la mañana.
Does he has any objection to the reset?
¿Usted tiene alguna objeción?
No.
No.
Position 23 is reset to January 25th, 2022.
Bien, entonces esta posición suya, la 23, está siendo reprogramada para el 25 de enero del 2022.
Lord, I need the key.
Okay.
Francois, we are done with Mr. Martinez. That case is concluded. Do you have another case that we can address with Mr. McLean?
I have position 3, Mr. Beta.
Okay.
Yes, Your Honor. I have 3, 13, and 14.
Okay.
That's correct.
Mr. Rahim Bethia is case 21 CR 004518C, accused of battery from August 26, 2021.
He was to be announced for today because he wanted to think about it overnight and possibly talk to family.
All right. Mr. Bethia, you have a right to remain silent as so previously advised, and your attorney is Mr. Mike McLean. The case has been scheduled for a possible plea or to be arraigned and further notice for reset for trial. How would you like to proceed?
I need to talk to him.
You need to do what now?
We spoke yesterday and I told him I'll talk to him today.
Okay. All right. Please have a seat and Mr. McLean will call you at the jail. Position, the other one was position 13.
13 and 14.
All right.
Now, is that 61220?
14 minutes, Mr. Johnson.
Just 1 second, please.
Barry, you still haven't spoke to McLean?
Position 13, so bonus Horton. Which one is Mr. Horton?
That's 13.
That was a plea. That was already a plea. So I'm real confused. Are we revisiting that case?
No,
He took a balance suspended, no theft class.
oh, that was, right, we did that one. I'm sorry, I'm getting the names mixed up.
Then the next one I have is
we did
Tony
that.
Johnson, Senior.
Tony Johnson Senior.
Do we have a Tony Johnson Senior in courtroom 2?
No, he's in 3 South right here.
Okay, 3 South, excuse me. And do you see him, Mr. McLean? He's at the 3 South location. You see him on your screen or on this?
I do, 3
Okay,
South. That's
great.
Mr. Johnson,
Okay.
yes.
So Mr. Tony Johnson Senior is case 22 CR 000126J, accused of affray fighting from an August 25th, 2021 incident. Mr. Johnson, you have a right to remain silent. Anything you say in open court, the statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Mike McLean. And with regards to Mr. Johnson, are we still proceeding with a negotiated plea?
Yes, Your Honor.
All right. For purposes of the plea, Mr. Johnson, may I place you under oath? Mr. Johnson, can you hear me?
Yes, I can hear you.
All right. For purposes of the plea, may I place you under oath if you raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right. Ms. Duncan, what is the recommendation for Mr. Johnson?
The state's recommendation in this case is time served, no further contact with Torrance Plen, that's TORRENCE Plen, PLENN. Stay away from all MARTA. Balance probated 40 hours of community service.
So it's 12 months, credit for time served, 40 days, served 40 days. Is that correct?
Yes, the state wasn't completely sure how many days he served for the array. He does have another battery charge with MARTA. So we took the credit for the 40 days he's been in for the other offense as the credit for this one as well.
August 25th.
I believe this one was actually just a citation. Let me correct that.
Okay, so it was an accusation. Okay. Mr. McLean, your client does have an open case with a $17,000 bond at the present time from a December 11, 2021 incident.
Yes, Your Honor.
Okay.
He does want to go ahead and take care of this and then deal with that later.
Okay.
The 40 hours of community service involved in this case, I asked him, can you do that? And he says, yes, I can do that at the food bank or a church.
All right. And do you stipulate to the factual basis, venue, and ID?
We do.
Mr. Johnson, as you are aware, you do have another open case, but are you prepared to move forward with this particular case in which you are cited for affray of fighting at a MARTA location?
Yes. Yes.
Are you under the influence of any kind of medication or alcoholic beverages?
No.
Are you satisfied with the representation of your attorney, Mr. McLean?
Yes, sir. Yes, ma'am.
And is anyone forcing you to take a plea today?
No, ma'am.
If you decide to plead guilty to the charge of affray, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to confront your accuser, examine witnesses, challenge the state's case, present defenses, as well as have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of affray?
Guilty.
Your sentence is 12 months to serve 40 days, credit for time served 40 days. You'll be placed on probation once you're released, during which time you have to complete 40 hours of voluntary community service. At all times, you have to stay away from all MARTA property while you're on probation. Once you've completed the 40 hours of voluntary community service, your probation will terminate and you can return to MARTA. Understood? Oh, that concludes this case. Oh, I'm sorry, and no contact with Torrance Glenn.
Yes, I understand.
Thank you.
Thank you, Your Honor.
Okay, do we have anyone else in courtroom 2 who doesn't need to speak to Mr. McLean?
I'm not sure which one is for McLean, but I have Mr. Lovett, position 19. Is he for McLean?
I do have that one.
All right, yes, position 19, Mr. McLean. And position 19 is going to be a non-negotiated plea. And this is Derek Lovett. I believe he wanted to.
The court, Your Honor, had accepted the state's recommendation, and then the defendant wanted to speak with his attorney.
Okay, that's right. It was. Have you spoken to him, Mr. McLean?
Let's see, this is the, right, we've gone through the plea. Looking at my notes, we've gone through the plea. He did talk to me, Your Honor. And after talking with me, he has no further questions.
So are we proceeding with the plea?
I thought we had gotten through it. Perhaps we have not finished it. He is ready to proceed with the plea, yes.
Well, this was about 20 cases ago, so I honestly cannot recall what stage. So I'm going to redo it, but
Right.
I need to know whether he wants to proceed with the plea.
He does. That would be wise to make sure.
All right. Mr. Lovett, just to readdress your case, 22 CR 000089J, just to refresh my memory, I'm going to place you under oath again. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. And Mr. Long, I apologize, but if you could refresh my memory on what the state's recommendation was.
Yes, Your Honor. It is 12 months to serve, confinement for 90 days, credit for time served 15 days, balance suspended, stay away from 530 East Paces Ferry Road, which is the Ashley Gables Buckhead Apartments, concurrent on each count.
And he would have to spend an additional 30 days at the jail. Is that correct?
Yes, that's what we figured out, yes.
All right. And Mr. McLean,
That is correct.
and is your client willing to accept that?
Yes, and he wants to do that as a negotiator.
All right. And you stipulate to the factual basis, venue, and ID.
We do.
Mr. Lovett, you've heard the recommendation. Are you ready to move forward?
Yes, Your Honor.
You can put your hand down. You've already been sworn. All right, Mr. Lovett, if you decide to take this plea, first of all, have you understood the proceedings so far?
Yes, I get credit for time served 15 days, an additional 30. Yes, ma'am.
And are you under the influence of any kind of medication or alcoholic beverages?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes.
If you decide to accept this plea today and plead guilty to criminal trespass and willful, was it just going to be the trespass?
They were concurrent, both
counts.
identical and
Both
concurrent.
Yeah. If you plead guilty to trespass and willful obstruction of an officer, you would have to serve 30 more days at the Fulton County Jail, after which the sentence will be suspended, but you cannot return to the entire complex at the Ashley Gables Bucket Apartments. Is that what you've understood the sentence to be?
Yes, Your Honor. And just one thing, will I be released after I serve them 30 days?
After you serve 30 days, and if you have no additional open pending cases holding you at the jail, then you will be released.
Okay, thank you. I accept.
Well, that's good. But if you decide to accept, you have to waive your constitutional rights to appeal my sentence or modify it, to go back to court, to have a trial before a judge or a jury, to confront your accuser, examine witnesses, have an assistance of counsel to challenge the state's evidence or present your own defenses, as well as waive your right to have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these constitutional rights?
Mr. Wave, I'm right, Mr. McCain? Yes, I waive.
Do you need to talk to Mr.
No,
McLean?
I'll waive. I'll waive him because I'm gonna accept the plea.
How do you plead to 1 count of criminal trespass and 1 count of willful obstruction of an attorney? excuse me, of a law enforcement officer. Excuse me, it's getting modern now.
Guilty.
Okay. Your sentence is going to be concurrent for both offenses, and it is 12 months to serve 90 days. Credit for time served, 15 days. So you have 30 more days to serve at the jail. If you have no other cases holding you at the jail, you'll be released after 30 days. Once released, your balance is suspended, but you cannot return to the Ashley Gables Buckhead Apartments. If you return to that location, they will welcome you with open arms with an arrest warrant and have you sent back to jail, where you get to spend, I don't know how many more days before we get to do this all over again. So it's really up to you whether you would like to come back to jail or not.
Yes, ma'am.
Thank you. That concludes this case.
Your
Right, the other cases we have-
Barry.
Just one second. Francois, I'm sorry, what was that request,
The
question?
other cases that we have left, they're all for McLean. Mr. Bethea, position 3, Mr. Barry, position 4.
And Mr. Marcial, is that correct? Position 21.
Yes.
Do we know where Miss Position 33, Anthony Townsend is?
Okay, we can go down the calendar. Mr. McLean, did you want to go back out and speak to Mr. Marcial through the interpreter?
Yes.
Using, and
Yes,
and Marcelo, would you please again call Mr. McLean and the jail so we can
Yes.
conclude the address issue with regards to Mr. Marcial?
Will do.
Also, Judge Law, what about position 3, Mr. Bethea, and position 4, Mr. Barry?
Right after Mr. McLean speaks to Mr. Marcial, he will call the jail to address the other two. Because I
Okay,
think they want to speak to their attorney.
okay.
That's going to be 612-2392.
2392. All right. Mr. McLean is going to be stepping outside. If Mr. Marcial wants to go to a separate location, the interpreter is going to call the jail. Okay, Mr. Howard, what are the positions you were asking about? 33,
Position 33.
Anthony Townsend.
Yes, Judge, that's a plea today.
Let's see. Francois, do you have any updates on position 33, Anthony Ray Townsend? Sorry, Francois, you're on mute.
I'm sorry, Judge Law, you said something that's a lot of noise.
Sorry, it is position 33, Anthony Ray Townsend. His attorney, Mr. Derek Howard, is trying to get an update. We were supposed to do a plea today.
Say the name again?
Anthony Ray Townsend.
I see it. Okay, actually he's actually in quarantine. That's gonna be a reset.
Is it? There's no way to get him because it would be time served. You just
I can
guarantee.
find out with my other coworker if he's willing to bring the phone down there, but he's in quarantine. He's in zone 600 in quarantine. But I can find out with my other coworker if he's willing to take the phone down there. He's on 1 North.
Your phone is not gonna work down there at all.
Oh, the phone, Mr. Howard, the cell phone doesn't work down there. So I do apologize about that. We also have another case that just came in. Mr. Davila, I believe it's position 11. Michael Davila.
Okay, has he spoken to Mr. McLean? Michael Lewis Davila. Is he in the courtroom?
Yes, he is. He just came in. Come here, sir.
And has he, no, I can't address him yet because his attorney is Mike McLean, who's unavailable at the present time.
All right, that's all of the cases we have left is for Mr. McLean.
Okay, we will hold until, I'm just going to go down the calendar just to get a status. Mr. Davila is position, what did you say? Position 11? All right, we have 4 cases on hold for Mr. McLean. Position 1, Sulaiman Bakr is going to be reset to February 3rd, 2022. And same announcement for position 2, same defendant, February 3rd. Position 3, we are holding on Mr. McLean. Position 4, we are holding on Mr. McLean. Position 5, 6, 7, and 8, Miles Bryant, have all been arraigned and further noticed to Judge Edie's division. Please make a note to the litigation manager. They need to be scheduled for I guess, a bond bond modification request. Position 9 has been arraigned and further noticed for trial. Position 10, Alante Coleman is reset 2 weeks out. Do we have a date?
Is that 2-3, Judge?
All right, so it's reset to February 3rd at defense request. Position 11 is on hold for Mr. McLean. Position 12, Time Hodges has been arraigned and further noticed for trial. Position 13, Fulton was a plea. 14, Johnson was a plea. 15, Jones is reset to January 27, 2022. Position 16, Keys is released. Position 17, Tommy King is reset to January 25th, 2022. Position 18 is further notice for trial. That particular matter is going to be addressed by the division judge. Position 19, Derek Levitt is, I believe, a plea. Position 20 is reset to January 27. This is an MH reset. '21 is a possible plea holding on Mr. McLean. Position 22 is reset to January 25th, 2022. Position 23 is reset to January 25th. Position 24 is reset to January 27, 2022. Position 25 has waived arraignment, so the case is further noticed for trial. Isaac Mquillo. Position 26 is reset to January 27, 2022. Position 27 was Mullinex, and that was a plea along with second case ending in 537H. Position 28 is reset, is an MH reset to February 8, 2022. Position 29, Palmer, is reset to January 25th, 2022. Position 30 was a plea. Position 31 was arraigned and further notice for trial. Position 32 was a plea. Position 33 is a quarantine reset. I didn't get a date. Mr. Howard, shall we try for 1 week out?
I would prefer this first possible date, the 25th, if they think he'll be available, because I was able to see him last night at the jail, so at the attorney booth. So I'm hoping we can figure something out.
But let's tentatively put it down for January 25th.
Yes.
Okay. And then if he does show up while we're addressing Mr. McLean's, then obviously we can proceed.
Okay.
Position 34, Upton was a plea. I have an add-on position on the calendar,
Yes.
and that is Christian Kearney,
Yes.
and he was released. So we're just going to be on hold until Mr. McLean returns to address the 4 cases that we have. Okay, we'll be in recess until Mr. McLean returns to the Zoom. Thank you.
All right, thank you.
McLean. Mr. McLean,
Yeah, we're all good. We're all good.
okay.
We're all good.
Do
Okay.
you have another client that still needs to talk with you? And then who's that? Who's ready? You done? Okay, Mr. Bethea.
There's another, who is that?
He
So-
still has to talk to.
Yeah. Let's do, who are we going to do first, Mr. McLean?
Bethea?
Bethea, position number 3. Rahim Bethea is accused of battery in 21 CR 004518C. And he's represented by counsel, Mr. Mike McLean, and he's been advised of his right to remain silent. What's the announcement, Mr. McLean?
He's pleading not guilty. I noticed that he was set to jail jury when it was on SAP before. He would like to ask for a signature bond since he is not moving forward on the plea today.
All right. Who's our prosecutor? Ms. Duncan?
It's me, Your Honor. So are we going forward with the bond hearing?
Yes.
Okay, so the bond for him is currently set at $5,000 cash bond.
Mhm.
And the state would request that that bond remain the same. In this case, the defendant is currently a fugitive from justice. And there is a GCIC note that they're for no bond because they're going to extradite. Given the circumstances surrounding the nature of this case and his case that he's wanted for out of New York is a felony manslaughter, the state will request that the bond remain the same because there has been no material change in
I'm
circumstances.
not wanted for no felony manslaughter.
Yes.
I'm on parole
The
for felony
bond
manslaughter.
was set.
Get that correct.
I'm sorry, I didn't hear what you just said.
I'm not wanted for no felony manslaughter. I'm on parole in New York for manslaughter. I'm on parole. I'm not wanted for felony manslaughter. I'm on parole.
So there's a parole hold
Yes.
for a manslaughter
Yes.
conviction. Is that correct?
I just came home in 2017 from doing 17 years on a manslaughter charge. I was on parole. They want me back on a parole violation.
So that's what I'm saying. It's a parole hold. It's a
Yes.
parole violation.
Yes.
You and I are
Parole
speaking
hold.
the same language,
Yes,
just
yes,
different
ma'am.
words.
Yes. It's a
Okay.
parole hold.
There is no open felony case. What
No,
you're
I
saying
don't
is
have
the
no
parole
open
hold.
case in New York.
Okay, all right. So how does that, Mr. McLean, how does that warrant a change to signature bond?
Well, he believes that a signature bond would allow him to go ahead and get shipped to New York, take care of his parole hearing. He is confident that he will do well in it, and then address this matter. He's concerned about doing what may be in the other state, quote, dead time, unquote.
Can I speak, Judge?
You have a right to remain silent, sir. Anything you say, your statements can and will be used against you. You can waive your right to remain silent, and just keeping in mind that your statements could incriminate you and also make it difficult for your attorney to defend you. So it's up to you.
I like
Your
that.
Honor, the state would just like to indicate that we have made contact with the victim in this case. And she stated that she fears the defendant and she thinks that if he gets out, he will come after her. She says that he has violated the no contact order by calling on a daily basis from jail, trying to force her to drop the charges. She said that she's suffering from PTSD. He did do the 17 years as he's mentioned. And she's talked about her injuries, bruises and bleeding from the hit that he gave to her on her face and head with the metal dog crate. She initially said that she will be on the Zoom, but she does not wish to speak for fear of the defendant retaliating. And she also said that the defendant has been calling her sister from jail, harassing her about making her drop the charges. I'm sure that Your Honor is aware of the facts in this case. And due to the violent and continuing nature, we just request that the bond remain.
Yeah, just 1 second, sir. The bond was issued on August 27, 2021, in which it expressly says no further contact with Dina Roach, which means that no contact directly or indirectly with any victim or victim's family member, professional, personal, or close associate, whether by phone, mail, email, pager, or any writing, sign, note, or message.
And Ms. Roach is on Zoom with us.
Hmm?
Ms. Roach is on Zoom with us.
Well, that's beside the point. I'm just trying to read the no further contact order. All right. Anything else to add, Mr. McLean?
No, Your Honor, he would like to ask for that signature bond so he can get on with that business, and he is confident that he'll do well.
All right. Could we unmute courtroom 2? All right. Yes. Mr. Bathia, I'm prepared to rule. Did you have anything else to add, or would you like to exercise your right to remain silent?
Yes, New York is coming to get me because of the nature of which I was,
Mr. Bathia, I'm very glad New York is willing to come and pick you up. But my next question is, do you have anything else to add, or do you want to exercise your right to remain silent?
I'm trying to address, I'm trying to add it now. I'm trying to speak my piece. New York is
All right.
trying to get me up. I'm not getting released from.
I'm concerned about the state's allegations that you've allegedly been reaching out to Miss Dina Roach from the jail.
I know that my family has tried to reach out to her. I have no control over what my family do because my family had their own rapport with her.
Okay.
She knows that I would never harm. I would never harm her. I would
Okay.
never harm her. I don't even know why she's saying that I would, and she know that I would never do that to her. I would never.
I'm reading the warrant, and the warrant is pretty disturbing. And based on your history, based on the egregious nature of the allegations, based on the fact that apparently either you or someone on your behalf has violated the no further contact provisions of the bond order, your request for a signature bond is denied. Your bond shall remain at a $5,000 cash bond. And of course, if you do put up the $5,000 cash bond, then I'm sure the New York authorities will be more than interested in having you extradited to New York City on this parole by hold.
Okay, so my next statement is this. When I was here on the 9th of September, I already told you I wanted to go to trial. Like, why am I here again?
The division judge in your case is Judge Myra Dixon, and your attorney will reach out to the litigation manager to get an update on the trial calendar. Thank you. That concludes this case. This case has been arraigned. It was arraigned on September 9th, 2021, and it's further notice for trial before Judge Dixon.
Thank you, Your Honor.
Shall we address Mr. Maciel and complete the plea, Mr. McLean?
Yes, Your Honor. Basically, let me state.
Mr. Maciel,
is he listening?
Yes, and Mr. Cedeno is there. Okay, go ahead.
Bien.
Basically, Mr. McLean?
He was unaware that there are other churches which do have homeless services for communication that he could check with every day. He could use Central Presbyterian right here a block away from where we are. He could use the Presbyterian church that's on the side street, I believe it's 16th or 17th Street, right next to the Arts Center of Atlanta, the Memorial Arts Center.
Bien. Su abogado está diciendo, señor, de que usted no sabía que existían estos otros servicios de las otras iglesias, como por ejemplo la Iglesia Central Presbyteriana, que está como a una cuadra de acá, y la Iglesia Presbyteriana del Sur, que creo que está en la calle 16 o 17. Él no sabía que esto es algo que él podía utilizar, que es para personas sin hogar, donde pueden recibir la correspondencia.
I feel confident that the Presbyterian Church next to the High Museum of Art on Peachtree Street and the Central Presbyterian Church a block away from the courthouse and next to the Gold Dome of the state capitol do have these services. And even if we don't know St. Luke's has one, it would be sufficient to instruct him to go to one of those, to pick one,
Okay.
and just to go to one of those and start using it.
Bien, entonces, pues como dije, hay varias iglesias. Hay una que está cerca del Capitolio, la Iglesia Presbiteriana Central, que es la que está cerca de acá. Y yo creo que, sabiendo que ellos tienen estos servicios donde les pueden enviar notificaciones al Señor, incluso la de San Lux, no sabemos si tiene ese servicio, pero nosotros le instruimos a él, él podría ir a revisar su correspondencia todos los días.
All right.
And let me say, Your Honor, in either case, Mr. Marcial, this all depends on your willingness to follow through and check your mail every day at such a location.
Entonces, habiendo dicho eso, pues nosotros entendemos que esta es la responsabilidad del señor Marcial de revisar todo esto todos los días en los diferentes lugares.
So should we say Central Presbyterian or the other one?
Entonces, podríamos decir la Iglesia Presbiteriana Central o la otra.
Shall we unmute courtroom 2, please?
Muy bien, encendámosle el micrófono a la número 2, por favor.
Mr. Marcio, if you decide to accept this plea, you will have to report to your probation officer within 48 hours of being released.
Señor Marcial, si usted decide aceptar este alegato, usted tendría que reportarse con la persona de probatoria dentro de 48 horas luego de haber salido de la cárcel.
We need to unmute courtroom 2 so he can respond.
Que necesitamos encender el micrófono para que le pueda responder.
Sorry.
That's okay. Again, Mr. Marcial, if you decide to plead guilty to these two cases for
Señor
criminal
Marcial,
trespass,
si usted decide declararse culpable de estas dos acusaciones de allanamiento de morada,
you have to report to your probation officer within 48 hours, within 2 days of being released.
usted tiene que reportarse con el agente de probatoria dentro de 48 horas luego de que lo dejen salir.
Sí, está bien.
Okay.
And by the time you go back for your second visit, 1 month later, you must give us a definite mailing address at any of the churches you choose.
Entonces, cuando usted se presente en 48 horas, usted tiene que darnos una dirección definitiva de una de las iglesias que usted elija para recibir su correspondencia.
Sí, está bien.
Okay.
If you don't give us a mailing address, if you don't report to probation, if you don't complete any of your conditions, we will have you brought back to jail and serve out the rest of the 12 months in prison.
Bien, si usted no nos proporciona con una dirección, si usted no se reporta a probatoria o si no cumple con las instrucciones que nosotros le hemos dado, los requerimientos, nosotros impondremos una orden de arresto y es posible que usted pase el resto de los 12 meses en la cárcel.
Está bien.
Okay.
Sí.
Yes.
Will he comply with the conditions?
¿Usted completará todas las condiciones impuestas?
Sí, está bien. Voy a la iglesia a buscar la dirección, a buscar mi correspondencia, está bien.
Yes, I'll go to the church and to pick up my mail, my correspondence.
More important, he cannot go back to the old Wheat Street Baptist Church on Irvin Street. He cannot go back to that location.
Entonces, lo más importante es que usted que sepa que no puede regresar a la Old Wheat Street, esta iglesia que queda en la calle Irving Street, perdón, la iglesia que está en la calle Irving Street, ¿entiende?
Sí, entiendo.
Yes, I understand.
All right, Mr. McLean, you've stipulated to the factual basis, venue and ID for both cases, yes?
Yes.
All right.
Y
And
nosotros-
Mr. Marcial, please raise your right hand.
Señor Marcial, levante su mano derecha.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
¿Usted jura que la declaración que dará será la verdad y toda la verdad?
Sí.
Yes.
You are facing 1 count of criminal trespass in case ending in 7588H. And in case ending with 1403Y, you're facing 1 count of criminal trespass and 1 count of willful obstruction of an officer.
Señor, usted está encarando dos acusaciones. La primera, que lo acusa con allanamiento de morada, es el caso que termina en 7588H. Y el segundo caso es el que termina en 1403Y. Usted está siendo acusado también de allanamiento de morada y también de obstrucción de un agente de la policía.
Do you understand that we are addressing both your cases?
Usted entiende que nosotros estamos procediendo con ambos casos.
Sí.
Yes.
You will be on probation for 2 cases.
Usted va a estar bajo probatoria por 2 casos.
Sí, está bien.
Okay.
Are you under the influence of any kind of medication, drugs, or alcoholic beverages?
¿Usted se encuentra bajo la influencia de algún tipo de drogas, medicinas o de alcohol?
No.
No.
Are you satisfied with your attorney's representation?
¿Está usted satisfecho con la representación que le ha presentado su abogado?
Sí.
Yes.
If you enter a guilty plea to these charges, you have to give up your right to go back to court and have a trial.
Si usted decide declararse culpable, usted está renunciando al derecho que usted tiene de regresar al tribunal y pedir un juicio.
To have your attorney assist you to challenge the state's case and examine witnesses.
De pedirle a su abogado que le ayude a presentar el caso ante la fiscalía y ayudarle a también a examinar testigos.
To present any defenses.
Presentar su propia defensa.
And have the state try to prove the charges against you beyond a reasonable doubt.
Sí,
Y exigir que la fiscalía pruebe los casos en contra suya más allá de una duda razonable.
no, está bien, así yo me declaro culpable ya.
No, I'm just going to plead guilty.
Well, that's fine, but you must knowingly and voluntarily give up your constitutional rights if you want to plead.
Está bien, señor, pero para que usted se declare, usted tiene que hacerlo conociendo los derechos constitucionales a los que usted renuncia.
Okay.
Ok.
Are you willing to waive these rights?
¿Usted está dispuesto a renunciar a estos derechos? Yes.
I'm sorry, I didn't hear him.
¿Cuál es su respuesta, señor?
Sí.
Yes.
Estoy de acuerdo.
Yes, I agree.
And Mr. Marcial, if you decide to take this plea, you will be responsible on how it has an effect on any immigration issues you may have.
Y señor, si usted decide declararse culpable, usted también debe de saber que esto puede tener efectos en su estado migratorio.
Sí, sí.
Yes.
How do you plead to 1 count of criminal trespass in case ending in 7588H?
¿Cómo se declara usted a la acusación de allanamiento de morada en el caso que termina en 7588H?
De que vivía en una propiedad privada.
Is that the trespass, Your Honor?
That is the trespass on December 15, 2021.
Sí, ese es por traspasar una propiedad del 15 de diciembre de 2021.
Me estoy declarando culpable, pero pues yo como le dije hace rato, yo no me metí nomás por meterme, sino que ahí viven unos familiares míos y me dieron permiso de vivir ahí, no adentro de sus casas, afuera. Yo puse una lonita ahí donde no me mojara, una lona donde me protegiera del sol, pero dentro de los apartamentos yo no vivo, afuera, es como en la yarda.
So as I'm pleading guilty, but as I was saying before, I didn't trespass that property because I have family members who live there and they allowed me to stay with them. And I wasn't living inside any apartments. I was actually living outside. I had my own tent to protect me from the sun and the rain. And I was like living out in the yard, but that was because my family members allowed me to move into that property.
Well, if this is not a plea, then I'm not going to take the plea and we can reset the case for trial.
Bien, si esto es un alegato de inocencia, entonces no voy a aceptar su alegato de culpabilidad y vamos a tener que poner su caso en un calendario de juicios.
No, yo nomás le estoy diciendo que
I'm going to ask him again, how does he plead to the 1 count of criminal trespass in case 21 CR 007-588H from a December 15, 2021 incident?
Bien, entonces yo le voy a preguntar, señor, nuevamente, ¿cómo se quiere usted declarar a la acusación 21 CR 007588H del 15 de diciembre del 2021 que lo acusa con allanamiento de morada.
Pero está bien, me declaro culpable. Porque
Okay, I'm gonna plead guilty.
How do you plead to case number 21 CR 0014003Y, criminal trespass and willful obstruction of an officer at the Old Wheat Street Baptist Church?
Bien, ¿y cómo se declara usted a la acusación número 21 CR 001403Y que lo acusa en una acusación por allanamiento de morada y una segunda acusación por obstrucción de un agente de la policía, lo que ocurrió en la Old Wheat Street Baptist Church?
¿Qué significa obstrucción? No lo entiendo.
What is obstruction? I don't understand that.
If Mr. Marcial has not asked these questions, then he's not prepared to take the plea.
Si el señor Marcial no ha realizado estas preguntas anteriormente, no está preparado para entrar su alegato de culpabilidad.
Right? Mr. Marcial, you've already had multiple conferences with your attorney and you do not understand the nature of this charge. I'm not comfortable taking this plea.
Señor Marcial, usted ha tenido ya varias conversaciones con su abogado y si usted aún no sabe a ciencia cierta cuál es la naturaleza de las acusaciones, yo no me siento cómoda aceptando su alegato de culpabilidad.
I will take the plea for case ending in 7588H.
Entonces yo voy a tomar su alegato con lo que respecta a la acusación que termina en 7588H.
Your sentence is 12 months to serve 60 days, credit for time served 37 days.
Su sentencia son 12 meses que esté encarcelado 60 días. Le vamos a dar crédito por los 37 días que ya estuvo en la cárcel.
You'll be placed on probation once you are released.
Lo van a poner bajo probatorio una vez que usted salga.
You are to stay 200 yards away from the 371 Irvin Street in the Old Wheat Street Baptist Church.
Usted debe mantenerse alejado de la calle 375 Irwin Street y también de la iglesia bautista, que es la Old Wheat Baptist Church.
While you're on probation, you have to complete an alcohol and drug evaluation.
Mientras esté bajo probatorio, tiene que completar una evaluación de drogas y alcohol.
You have to complete 40 hours of voluntary community service.
Tiene que completar 40 horas de servicio voluntario, de servicio.
And you're not to consume any illegal drugs, no alcoholic beverages, and not possess any weapons or firearms.
Y no puede consumir bebidas alcohólicas, utilizar drogas o poseer armas de fuego.
Sí, está bien.
Okay.
Within 48 hours of being released, you must report to your probation officer.
En 48 horas de que lo dejen salir, tiene que reunirse con su agente de probatoria, es decir, reportarse.
And by your second probation visit, you must give them a definite mailing address.
Y en su siguiente visita, usted tiene que darle su dirección de correo definitiva.
That's the plea I am accepting in case 21 CR 007588H only.
Entonces yo estoy aceptando su alegato de culpabilidad solamente en el caso 21 CR 007588H.
He still has a pending criminal case for willful obstruction of an officer and criminal trespass.
Todavía tiene un caso pendiente criminal sobre allanamiento de morada y obstrucción de un agente de la policía.
However, he has a $2,000 signature bond through the jail on that case.
Sin embargo, usted tiene $2,000 de fianza bajo palabra en ese caso.
He can be released on that bond.
Usted puede salir bajo palabra en ese caso.
And he has to stay away from the Old Wheat Street Baptist Church.
Y tiene que mantenerse alejado de la Old Wheat Street Baptist Church.
If he returns to that church, he will be in violation of probation and also a bench warrant will issue for his arrest.
Si usted regresa a esa iglesia, usted estaría en violación de su probatoria y se le impondría una orden de arresto.
Thank you.
Gracias. Is that all?
That's all. Thank you.
That's todo. You're
So,
not
Yes, Mr. Sedeno, just one second. We don't have any other interpreter cases in courtroom 2, yes?
Yes.
All right. Thank you, Marcelo. Really, really appreciate it today. Thank
My
you.
pleasure. Thank you.
All right.
Take care. Thank you.
Okay, Mr. McLean, we still have a couple of cases with you. Position 20, no, position 11.
11 is Mr. Davila. As of late last night, early this morning, the jail had moved him from one location to
Hang
another.
on, we have someone else in court. Who is in there?
I have him in courtroom too.
Who's seated next to you?
I have Mr. Berry, position number 20. Come on, Mr. Berry, sit down. Thank you.
Position 22,
He's number 3.
number 3.
Oh,
I'm sorry, number 4. Number 4, not 3.
No. Position Montrese Berry, is that you?
Yes, number 4. Position number
Okay.
4.
Number 4.
Mr. Beard,
Yes, and you wanted to speak to Mr. McLean. Have you spoken to him?
Yes, that's
Yeah.
spoken to. Yeah, we spoke.
And what are we doing?
A plea.
All right. So this would be time served on one count of simple battery, domestic violence, no contact with the victim, and to stay away from the location. Is that correct, Ms. Tortorella?
It's just no contact with the victims. If Your Honor wants to add a stay away, that's fine. And the victims' names are Tiara Hood. For the record, it's Tiara. Last name Hood, traditional spelling, and Harmony Berry, Harmony traditional spelling, and Berry traditional spelling.
Okay. All right,
And
is there, is Harmony a minor?
Yes, Your Honor.
All right, and is there any visitation or any issues? I'm assuming that's his child. I'm just going by the last name.
That it is his child, Your Honor. But given the current case that he has up in Superior Court against the same victim, Your Honor, we are asking for just no contact.
All right. Mr. McLean?
Your Honor, on the misdemeanor cases, he does understand the distinction between the felony and the misdemeanor realms. On the misdemeanor cases, he would like to go forward with this negotiated plea.
And do you stipulate to factual basis, venue, and ID?
We do.
So Ms. Tortorella, we are going to null pros criminal trespass, damage to property, one of the counts of simple battery, domestic violence, and simple assault, domestic violence. Is that correct?
That's correct, Your Honor.
Okay, please submit the null pros order to and email it to april.champion@fultoncountyga.gov.
Yes, Your Honor.
Mr. Berry, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, are you under the influence of any kind of alcoholic beverages or medication?
No, ma'am.
And are you satisfied with the representation of your attorney, Mr. McLean?
Ma'am.
If you decide to go forward with this plea, you would have to give up your right to appeal my decision that I imposed today. Are you prepared to do that?
Yes, ma'am.
You will also have to give up your right to go back to court to challenge this case in a court of law before a judge or a jury, to have the assistance of counsel to present your defenses, evidence to challenge the state's case, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to move forward and waive your rights?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
Now, with respect to only this misdemeanor case, no other cases, only this misdemeanor case ending in 5632H, how do you plead to one count of simple battery domestic violence?
Guilty, ma'am.
Repeat.
Guilty, ma'am.
I accept your guilty plea. Your sentence is time served, balance suspended. You are to have no contact with Tiara Hood and Harmony Berry until further order of the court. Understood? Anything else, Ms. Tortorella?
No, Your Honor, that concludes my business for this calendar. May I be excused?
Yes, thank you.
Thank you, Your Honor.
Question, though. I got a question.
Yes, Mr. Berry.
I heard you all say something about my probation. When is that court date again for the probation verification?
Got a probation hearing?
Yeah, for felony probation verification, when is that court date for that?
I don't know which case.
Your Honor, I announced earlier, excuse me, I announced earlier that for the 19 SC 164697 aggravated assault case, he has a probation revocation hearing on January 24th of 2022 due to violating his probation while on probation for that charge.
All right, and he's got that other case, 21 CP 20379 something.
Yes, that's the one against the same victim, Your Honor. That's the criminal damage to property felony charge. It's still in the complaint room.
Okay.
Up
All
at
right.
the DA's office.
Okay.
Thank you.
Thank you. Okay, so positions 3 and 4 are resolved. Position 11, Mr. Davila, I believe that's the only one left for
That's
Mr.
the
McLean.
only one left. What number do I call him on, Your Honor? Last night at the jail, he was not available. They had.
Call the same number.
612-2392.
Okay, very good. I'll call him.
Come on, we gonna call you, okay?
All right, courtroom 2 will be in recess until Mr. McLean returns for Mr. Davila's case. Okay. Let's readdress Mr. Michael Louis Davila, accused of simple battery domestic violence, 21 CR 005-090J. Mr. Davila, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Mike McLean is representing you. How are we proceeding, Mr. McLean?
Negotiated plea today, Your Honor.
All right. Mr. Davila, if you could please raise your right hand, unmute courtroom 2, please. Sorry, we're taking a plea. Mr. Davila, do you solemnly swear and affirm that the testimony you provide for this plea hearing is the truth to the best of your knowledge?
Yes.
I'm sorry?
Yes.
Thank you. All right, the prosecutor is going to let me know. You can put your hand down, sir. What is the recommendation?
The state's recommendation in this case is 12 months to serve, 45 days, credit for time served, 45 days. No further contact with Everett Simmons, no alcohol, drugs, or weapons. Stay away from 1197 Joseph E. Boone Boulevard Northwest in Atlanta, which we had as the victim's address. If that's not the victim's address, wherever the victim resides. 80 hours of community service and the Family Violence Intervention Program.
Mr. McLean?
That is his understanding, and he does stipulate to the required elements.
Factual basis, venue, and ID, correct?
Yes, he does.
All right. Mr. Davila, are you under the influence of any kind of medication or alcoholic beverages?
No.
Are you satisfied with the representation of Mr. McLean?
Yes.
And is anyone forcing you to take a plea today?
No.
If you decide to plead guilty to this charge today, you would have to waive your constitutional right to go back to court, to have a trial before a judge or a jury, to confront your accuser and examine witnesses, present evidence of any defenses you may have, as well as challenge the state's case, and also have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? Mr. Davila, do you have a response? I'm sorry, I cannot hear you and I don't understand the response you made.
Good. Do the requirements that are.
Mr. Davila, that is non-responsive to my question. My question to you again is, you have certain constitutional rights in which you can go back to court, have a trial before a judge or a jury. You can have the assistance of counsel to present evidence to challenge the state's case, to present your own defenses, and to confront your accuser and examine and cross-examine witnesses. You also have a right to argue your case before a judge or a jury with the assistance of counsel, and possibly be either acquitted of the charge, or if the state proves the charge against you beyond a reasonable doubt, you would then be convicted. But these are rights that you would have to give up if you decide to plead guilty today and accept the recommended sentence. So again, are you prepared to give up the rights I've just indicated?
Am I prepared to give up those rights? I'm really not, no.
All right, this is not a plea. I'm prepared to arraign the case. I'm not accepting a plea. Mr. McLean, is your client prepared to enter a not guilty plea?
If he is not waiving his jury trial rights, that would be a not guilty, and please set it down for trial.
All right. Do you waive a reading of the accusation?
We have the accusation, and I can provide it to him. I think it'd be best to read it to him, though.
Okay.
Really do.
This is State versus Michael Louis Davila, case number 21 CR 005-090J. As the court has not accepted the plea with regards to Mr. Davila, this case is going to be arraigned. In other words, Mr. Davila is going to enter a plea of not guilty, and the case will be scheduled for trial so that he may exercise his constitutional rights as they have just been stated to him, to which he has not waived. He is accused of simple battery domestic violence in this particular case, and the accusation was filed on September 27th, 2021, in which the Solicitor General's Office of Fulton County does accuse the defendant, Michael Lewis Davila, of simple battery domestic violence on that September 25th, 2021, allegedly in Fulton County, Georgia. The accused did intentionally make physical contact of an insulting or provoking nature with the person of Everett Simmons, to wit, striking Everett Simmons in the shoulder, who is the other person formerly living in the same household of the accused, in violation of Georgia law, OCGA 16-5-23F. With regard to this accusation, Mr. Davila is presumed innocent of the charge until the case goes to trial. Upon his entry of a not guilty plea, the case will be scheduled for trial, in which the state has the complete burden to prove the charge against him beyond a reasonable doubt. If the state prevails, he could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, Mr. Davila, and the fact that your plea is not accepted, how do you plead?
I will plead not guilty.
Your case has been arraigned. It's going to be further notice for trial. That concludes this case. Thank you.
Thank you, Your Honor.
Thank you, courtroom 2. I appreciate all your help. Thank you so much. Take care.
Thank you.
So it looks like the judge logged off the calendar, but make sure y'all send all your bond orders and plea paperwork to april.champion@fultoncountyga.gov.